From the supplementary list under heading for mediation
From
for
the
the
list, item 125. There will be list. It is in the board in the heading of orders. Though the delay has been condoned, one is IF is pending for history of extinction. The learner is Supreme Court is pursuing extinction proceeding.
Who's
But
for that?
the appeal has not been admitted as yet. And I have called the other side, Mr. Rahul.
If it has not been admitted first, it has to be heard.
हाँ,
सवा 2 बजे आइए. कौन सा फाइल दे दीजिए.
Item number 25.
ठीक. सवा 2 बजे. नहीं, सवा 2 बजे नहीं. हम लोग का 12:30 बजे ऑर्डर फॉर.
ठीक.
from the supplementary list under heading for mediation for the nationwide group, item 3, second appeal 65 of 2010.
Where is the other side? डेट फिक्स करेंगे ना. अदर साइड कहाँ है? स्नेहा सिंह. अभी एक सुप्रीम कोर्ट से सर्कुलर आया है कि मीडिएशन में बेसिस हमें डेट फिक्स करना है. तो अगर डेट पार्टी नहीं रहेगा तो किसको डेट देंगे हम अपीयर होने के लिए?
Mahesh Kumar Verma and Vednath Mishra.
Oh.
They are
इनका फोन नंबर वगैरह है?
ये लोग यहाँ आने लिस्ट करने से पहले भी फोन करके हम उससे कंसेंट लेते हैं, तभी उसको लिस्ट करते हैं, क्योंकि हमसे फोन करके पूछे
क्या?
हाँ, फोन करके पूछे हैं, मतलब पार्टी नहीं लोग, हमको लगता है लिस्टिंग
हाँ, लिस्टिंग डिपार्टमेंट
पूछते हैं, उसके बाद ही फिर लिस्ट करते हैं.
पूछिए होंगे, जरूर पूछिए.
तो दोनों साइड से पूछो.
Okay, let this matter be sent for mediation. The office is directed to place this case immediately upon receipt of mediation.
Item 4, second appeal 81 of 2010.
Yes. Mediation में भेजना है? बोली के बाद थोड़ी mediation ड्राइव खत्म हो जाएगा. देखिए, the learned counsel for the respondent is not ready for mediation. Accordingly, the matter cannot be sent for mediation. The case is otherwise ready for final disposal. Post this case for final disposal on 26th. 26 तारीख को हियरिंग करेंगे. चलिए नेक्स्ट केस.
Item 5, second appeal 413 of 2017.
Yes. 9. 5. Substantial question of law has been framed.
Admit, yes. Admit on 77.
प्रीवियस फाइल दीजिए तो केस का नंबर क्या है नहीं प्रीवियस केस ना वो दिखाइए प्रीवियस केस का फाइल प्रीवियस केस का जो अभी जो 26 तारीख को दिया
जी 81 ऑफ 2010 है जी इसमें थोड़ा सा हाइड कर देंगे
आप जब वो वाला केस दिए थे ना तब ये वाला फाइल दिए
ये गड़बड़ हो गई थी ये सही है।
ऐसे कैसे गड़बड़ होता है
ये ठीक है।
हाँ?
पीछे गलती हो गई।
दूसरा फाइल ले दिया था हम देखे सेम
जी,
सब्सटैंशियल
same।
क्वेश्चन ऑफ लॉ मतलब दो केस में सेम सब्सटैंशियल क्वेश्चन
कौन से पूछे हम बोले कि मैटर डिसाइड हो चुकी है
the appellant is not ready for mediation. Post this case for final disposal on 25th, 25 फरवरी. आप अपने पेरेंट्स दीजिए. क्या नाम है आपका? प्रत्युष. नया ज्वाइन किया. पता लग जाता है नया ज्वाइन किया. कहाँ से पास किया? How long have you been practicing?
5 months.
5?
5 months.
You are with whom? बता दीजिएगा हमको फाइनल डिस्पोजल के लिए मैटर है. आप तैयार हो जाइए.
Under heading for orders with effect, item 1 second appeal 14811 of 2025.
Yes. Right. 5. First, the defect is to be ignored.
The defect was regarding in the include order lawsuit. There is a Tulsi Mandal was the appellant number 1. He has died, so we have not let him party or lawsuit.
When did he die?
Died on 27/8/2025.
After the degree.
The date of decree is 1924 is 13/12/24 is the decree after this decree.
How much is the delay?
275 days.
I number 1304 of 26 has been filed. Seeking ignoring the defect. The learned counsel for the appellant has submitted that appellant number 1 has expired on 27/8/25. Death certificate कहाँ है? However, the death certificate has not been placed on record. कितना टाइम लगाइएगा? डेथ सर्टिफिकेट post this case on 12th of March. In the meantime, the death certificate should be filed.
Collective item 6 in illegal fighters will call again additional item content. Item 6 second appeal 477 of 2017.
आपके सर कोई एडिशनल आगे नहीं दिया है समिति छुट्टी पर
थोड़ा सा
हैं उनको बुलाइए.
I had not consented
listed for mediation.
यू आर देयर, आप केस कॉल कर लेंगे सर, आप जाइए बैच मैटर में जाके काम करें,
जी
ठीक है? आराम से, कोई ऐसा हड़बड़ी का बात नहीं है, ठीक है?
ठीक है
आप जाके कर लीजिए, इनको करने दीजिए,
ठीक
इसको अपलोड करना जरूरी है ना? यस प्लीज, यू हैव नॉट कंसिडर्ड फॉर मीडिएशन. Okay, substantial question of law has been framed.
It has not been followed in lordship. Another connected second appeal 429 of that has been admitted. And it has been listed for orders on 25/3/26. So this matter
Why is it listed for orders?
it was for notice lordship. Maybe for service of notice. Another second appeal has been listed.
Arising out of the same judgment.
judgment.
Who has filed that second appeal?
The respondent in this appeal.
Both of them are aggrieved.
Yes.
It's a partition suit.
No, it is not partition, it is declaratory suit. Declaration for the status of wife, first wife, as well as proportionary right of the 4 minor children, the then minor children.
Okay.
Now they all are major.
So there is a finding against you.
Reversal, judgment of reversal. Trial court decreed in my favor.
In that case, the substantial question
Yes,
of law
ma'am.
has been framed.
Yes, sir.
The order has been uploaded.
Yes, sir.
Where is that order?
My order dated 22/12/25.
22.
12/25.
ये जरा ऑर्डर निकाल लीजिए. एक्सक्यूज मी, ऑर्डर निकाल सकेंगे?
429 of 70.
ऐसे नंबर
429 of 70.
429 of
70.
Are you ready for hearing under order 41?
Today itself,
So when do you want to do it? You can do it tomorrow.
next week or next month, whatever.
Okay. Essay number 477 of 2017. The learned counsel for the appellant submits that the appellant is not ready for mediation. The appeal has not yet been admitted. Another appeal arising out of the same judgment has been admitted on 22/12/25, being essay number 429 of 2017. Pose this case, otherwise ready?
The substantial question of law formulated in the other second appeal need to be reformulated.
That you will raise at that point. Post on 18th February under appropriate.
Now from daily politics, target list cases, serial number 1 case 170 of 2002.
उसमें एक नवीन सी आई नंबर 13757 इसमें इशू नोटिस हुआ था वो सब सर्विस होंगे एक नहीं
नोटिस किस पे हुआ?
आईए नंबर 1
लिमिटेशन.
नहीं सब्स्टिट्यूशन ब्लॉक
आइए नंबर
13753
who has not been served?
I mean, for me to take fresh steps in conjunction with the
She's a sister.
Yes.
Unserved क्यों आ गया? कुछ लिखा भी नहीं है। आपके ट्रैकिंग रिपोर्ट में क्या बताते हैं इसका? Essay number 170 of 2002. The notice upon proposed legal hearing of respondent number 1, namely 1 with bracket B, has returned unserved. Counsel for the appellant. Praise for and is granted 1 week time,
2 weeks.
2 weeks time to take fresh steps upon service of notice upon respondent proposed respondent number 1 within bracket B at a present and correct address, or to take appropriate steps for substituted service of notice. किससे जाएगा? थ्रू कुरियर?
नहीं, स्पीड पोस्ट
थ्रू स्पीड पोस्ट करिएगा। Post on 25th, 26th.
Now under the heading hearing, serial number 2, essay 126 of 2003.
Appellant. तो अबेट कर गया ना प्रोसीडिंग? Essay number 126 of 2003. Nobody appears on behalf of the appellant. The proceeding against appellant number 1, respondent number 1, has already awaited. Which is apparent from order dated 21/1/2026. The matter is adjourned and is directed to be posted on 12th of March, subject to payment of cost of rupees 20,000. The cost should be deposited latest by 10th of March, failing which this appeal shall stand dismissed without reference to bench.
Now serial number 3, SA 352 of 2004.
Since the counsel for the appellant is absent, let a copy of this order be communicated to the counsel for compliance. Yes. हाँ, आप अपना मेमो ऑफ अपील
Along with scope.
Yes. एक सेकेंड और लिखिएगा, the cost be deposited in the registry. नहीं, इनका एडवोकेट क्लर्क एसोसिएशन का एड्रेस है ना, वो दे दीजिए. Yes, please.
Well, the Rotary Club is section 357. There's a common order in both the title suit and in the appeal.
What is the substantial question of that?
Well, three substantial questions of how we're feeling. Whether in the absence of proper notice, the board could raise demands on the basis of 240 kVA. Whether the board was duly bound to install a proper meter for recording maximum demand. And thirdly, whether the plaintiffs or league appellants are entitled to remission for the period of non-supply of power. These are the three substantial questions.
Where is the order?
My lord.
Where is the order by which the substantial question of law has been obtained? Your bank guarantee is alive?
No, my lord. I am informed that all payments have been made.
All payments have been made?
Yes, your lord.
All the dues are cleared?
Okay.
Why do you want to unnecessarily?
But there was not much in the appeal, your lordship. I am not even with your lordships, because your lordship permits have got the lower court records very recently. I've taken some printouts.
That's fine, but payment has been made. What kind of litigation is this? Are
Why
you
not?
really interested?
Not really, your lordship.
You just
But
take instructions. What's the big idea? You
I'll
have
take
already-
instructions, your lordship, because there's not much in it also.
You take instructions. Why should
No,
we
no, my lord,
unnecessarily?
absolutely agree. I go down to your lordship. I've already suggested to them.
Yeah.
But since now things are much further away in Tata Steel, your lordship, everything is in Bombay. I'm having some trouble communicating with them, but because if it was locally, then but I go down to your lordship because there's not really much work. So evidence is all that.
Duty of the board to install the proper meter.
There's an agreement, there is a tariff. We
It's
are
a
bound by the
tariff.
tariff.
Bound
There's
by
not
the
a-
tariff.
Yes, your lordship, that is the finding.
So let's decide then. They
If
they
your lordship
are
posts
they are
the
they are
approval,
more bureaucratic than the
if your
government.
lordship
also.
grants me a month's time,
Not months time. Not in a case like this.
in 15 days time, let me just take instructions.
Not no instructions.
Already,
Your
then-
client will not give you any instructions.
So
Where
I
is
can
the other
try.
side?
Once I have the year of the court, then I can always.
From where do you say that the amount has been paid?
That's what I've been informed.
No, you renew the bank guarantee. I'll ask you to renew the bank guarantee.
Let it come up after 2 weeks, then I'll get the full details. Because some-
I will do
some-
one thing.
My-
I'll ask you to renew the bank guarantee. If you do not renew the bank guarantee, then I will say that the appeal will stand dismissed.
My lord, that can be done. I am told that all payments have been made.
Your statement is not sufficient.
No,
There is an
that's-
order of the court that you have to keep the bank guarantee alive.
No, subsequently, your lordship, certain filings were done. I don't really have the full file. That is the problem. Yes, Your Lordship, I have it here. There's an IA which was filed, I don't have the number of the IA. That the entire demand was paid to the respondents by the DT dated 19/11/2004. This fact was not brought to the notice of the Honorable Court. I don't have the IA number.
Alright, it is here, IA number 3150,
Of 2009.
2000. Any order passed on this?
I have a lateral entry with very little. That part has been addressed because I was informed that they have made.
No outstanding amount, entire amount stands paid. Okay, let's see the judgment.
Well, the trial court judgment is complete.
It's concurrent finding? Is it concurrent
Concurrent
finding?
finding on this. Starts at page 23. The trial court judgment in suit.
Just a minute. What was the suit for?
My lord, the suit, there were two suits, Your Lordship. Title suit 257 of 81 and 251 of 80 and 251 of 82, Your Lordship.
Yes?
In this case, Mr. Jharkhand has to due to some medical emergency, he has to He's not there.
Yesterday he was here only.
He was here, but today only. Just praying for one.
He has not come to the court.
uh,
He is not well or somebody else is not well?
I had instructions that he's not coming to court because of some medical emergency.
He is not well or somebody else is not well? I just want to know when should I post it?
But tomorrow it is.
Okay.
Your Lordship will not post it tomorrow. I'm
Right.
not here in the first half. So if Your Lordship posts it for day after or Monday.
Today is Wednesday, right?
My lord, Wednesday.
Next Wednesday.
We'll post it on Friday. Day after. Day after.
Oh, yes, Your Lord. Okay.
At the request of the learned counsel for the respondent and with the consent of the learned counsel for the appellant, pose this case for final disposal. These two cases for final disposal, day after tomorrow at 2 p.m.
My lord.
Obliged.
Thank you.
Now serial number 5, A6626 of 2015.
Matter relates to easement. What would be the impact?
Where is the substantial question of law?
In this case, I am repeating that yesterday only we have received.
So what should I do? You have not given any advance notice for adjournment. I will not give you adjournment like this. वकालतनामा कल लेके आए हैं 2015 के मैटर में I can't do it. I'll adjourn it for subject to cost. चलिए वकालतनामा कहाँ है?
फाइल
लेके आइए, फाइल तो करना पड़ेगा ना, कोई बात नहीं, चलिए. Yes.
There is one problem I must disclose.
What problem?
First, it was, you may see the order dated 25 to 2019.
I'm there.
Yes, 3 substantial questions of law were formulated. But then there was another order on 29/4/2025, where it has the 3rd substantial question of law. It was said that it is, although it has been made that I have submitted, but ultimately the order is that the 3rd substantial question of law is not applicable in this. This is one. Now I have
With
filed
the
one.
consent of both the parties. Open court में ही order हुआ होगा.
Yes.
So we will take it. The
Ah,
third
we
substantial
have to
question
take.
of law does not.
We have to take it. We have to take it.
Now we are survived with 2 substantial questions.
Yes. And I have filed one IA for reframing of the second one, second substantial question of law, because it was not properly worded. So I filed a IA. The second substantial question of law was whether right of easement can be said to be applicable, though not applicable, without giving proper appreciation to justice, equity, and good conscience. I have only added in my IA that whether the provisions of Easement Act can be applied when the Easement Act has not been
No, it's it
it
is
is
covered
even
by
a-
IA.
yes.
So you forget that IA. That IA is of no use.
And
That is only for technical.
I'll start to merit also. And the third
This IA we
question,
will reject. Just a moment. पहले इस IA को reject कर.
एक और हम एडिशनल क्वेश्चन उसी में और हम इसी के लिए बोल रहे हैं मेरा गलती है मान मेरा गलती है because I came across a Supreme Court recent judgment where it said that if a person has access to a road, then he cannot claim easement through someone else's property. So if when in the instant case I am the defendant, the other side is the plaintiff who has claimed the right of easement through my property.
You see whether the right of easement has been properly appreciated उसमें
Then
covered
that
है.
will cover.
फिर क्या है? Properly
वो
appreciated.
ठीक है हम मेरा ड्यूटी है
तो evidence आया होगा ना? There is an alternative approach.
हाँ वो फाइंडिंग
Evidence
में
आया होगा. Finding में है तो ठीक.
हाँ, ठीक है
अगर वो जजमेंट में
ठीक है।
जजमेंट्स तो आते रहेंगे
ठीक
नए
है।
जजमेंट्स में नए सब्सटेंशियल क्वेश्चन ऑफ लॉ
नहीं वो नया नहीं ऐसे भी आई मस्ट आल्सो एक्नॉलेज कि 2005 में भी एंड रिसेंटली 2024 in both the honorable court has said that if a person has an alternative access to his property then he is not entitled to claim easement on it.
Fair enough. You see, the Easement Act, being, as I was hearing in some other matter, has not been made applicable to the state of Bihar or state
In my another
in your other matter. But the law is equally settled that the principles would still apply.
principles of justice,
Yes.
equity and good conscience.
Yes.
This is the only.
Yes, this is the only thing.
So
And basically, easement is only justice, equity, and good conscience only. Primarily, it is based on this principle. Maybe it has been enacted, but primarily, the basic underlying principle is this one.
but what would happen here?
So now these two IA should I discuss?
As
First IA number.
11904.
1190. IA number 11904 of 2025. This petition has been filed for reformulating the substantial question of law number B and also for framing additional substantial question of law as mentioned in paragraph 5 and 6 of the interlocutory application.
That IA, my statement in fourth paragraph is erroneous. Subsequently, by order dated, the Honorable Court deleted or
Deleted
it is wrongly mentioned as framed.
so far as reformulating the substantial question of law number B is concerned, it has been mentioned in substantial question of law number B itself that the right of easement is not applicable. Just mentioned, yes?
Yes, was yesterday in a very short span of time, I was researching and I find out that the easement act was applicable in the state of Bihar. I was researching, but
Where is that?
But since very short time was available to me,
Where did you search this?
in online in net.
तो कहाँ मिला? कोई नोटिफिकेशन मिला होगा ना?
नोटिफिकेशन तो मुझे वैसे नहीं कुछ पाया, लेकिन वहाँ पे शॉर्ट ये था कि इट इज एप्लीकेबल इन द स्टेट ऑफ बिहार एंड बाय द वर्चू ऑफ रीऑर्गेनाइजेशन बिहार रीऑर्गेनाइजेशन एक्ट इट वाज नॉट कैरी फॉरवर्ड सिंस इट वाज नॉट
I did not get it. I must.
हमको भी मालूम है कि स्टेट ऑफ बिहार में एप्लीकेबल नहीं है.
Because there is a direct judgment which I had placed in 1935 Patna. It was clearly mentioned by the Honorable Court that it is not applicable, but the equity.
Principles will.
Yes,
Yes.
principles of this. So it has to be only after 1935 if there is anything by which the state has adopted. I did not get any. My learned friend has
However,
that.
it's also true that easement act में जो where it is been applicable subsequently कौन-कौन सा स्टेट अडॉप्ट किया वहाँ पे बिहार का नाम नहीं था. It's true, but it's
आपका नेट से चलेगा क्या?
नहीं उससे नहीं चलेगा. जो हम खाली सिर्फ यूज इतना बोले कि therefore हम उस पे लीगली उस पे हम नहीं आ रहे.
This was the reason that.
दो नॉट एप्लीकेबल लिखे हैं
Yes.
ना आप
So this was the reason that in another case, at the first, it was
Yes.
in Asha Mandal, the state was implemented as a party to answer to this question as to whether it is actually it has been adopted by the state of Jharkhand.
This court is not inclined to इतना ही लिख देते.
ठीक है,
To modify the substantial question of
ठीक
law
है, ठीक है.
already framed. Further, the
Para 6.
this court is further not inclined to frame the additional substantial question of law as suggested, as the right of the parties would depend upon the facts already established. ठीक है ना? Already established in the judgment passed by the learned courts. Okay? Yeah, ये rejected. उसके अलावा कौन सा आई है?
All right. मेरा CA का है.
स्टे का नहीं एक और आई है.
एक early hearing.
Early hearing.
कौन सा आई है नंबर? आई नंबर 1571 of 25. This petition has been filed for early hearing. Since the hearing of the case is being taken up today, the IA is closed. बताइए. It's concurrent finding.
Yes.
You can argue.
Then there was a leader commissioner appointed. His report may be seen that would clarify everything. And I must say against me also that there was a common owner of the property. She gives the property to the plaintiff, a portion of her entire property. She executes a registered deed of gift in favor of the plaintiff with regard to a portion of the land. Now there is a house constructed on that. Now thereafter she transfers after my vendor's deed is after the gifting, And in the gift deed, it has been mentioned that the donee would have a right to passage and staircase to access his own property. This is mentioned. Now, what happens that the property, adjacent property is now transferred to my vendor's vendor, my register. No such condition is there mentioned in our deed. No, neither restriction nor any withdrawal of that. Now, my vendor's vendor then transferred the property in 2000 to me. Then the plaintiff files a suit that although there has been a transfer, but according to the deed of deed, I have a right to access to the passage, staircase, and the rooftop to enter my house. This was the case. This was
Right
the
of easement, this right to passage is mentioned in the gift deed. It is also mentioned in the registered deed.
No, my deed, it was not. Only in the original gift deed, which was executed by the original owner of the
In your
property.
deed, it is not mentioned.
No.
So, if
But
the,
my deed is subsequently appointed.
therefore the right has already accrued,
Now,
it survives.
no. Why, therefore, it was a case of easement. So, if easementary right. So, therefore, I said that if you
Easementary right based on title,
based on a document.
based on a document.
Yes, yes.
So it is not a case that a person is landlocked, he doesn't have any access to the land, and he's seeking some new right. That right was already existing in the gift deed.
It was
He's
there.
seeking
It was
enforcement of a right which is already there in the gift deed. So when the donor sells the remaining property, then under such circumstances it is all subject to gift.
Therefore, I said that what was the claim of the plaintiff, that would be clear from the report of the.
कुछ जबरदस्ती नहीं है.
नहीं, जबरदस्ती नहीं. ये क्या है वो दिखा, इसी के लिए तो हम बोल रहे हैं. क्या है? एक बार रिपोर्ट में काइंडली विजिट.
आप पहले प्रेयर देखिए.
मेरा प्रेयर नहीं है, यही तो प्रॉब्लम.
किसी का भी प्रेयर है.
हाँ.
आखिर सूट में प्रेयर तो देखेंगे ना.
ये जो प्लेट सूट का.
हाँ, सूट का प्लेट का प्रेयर देखिए.
Particularly, we passed that the defendant is not entitled to obstruct the common passage and utilized by the plaintiff, and an injunction restraining the defendant from obstructing the common passage of the plaintiff and directing the defendant to remove the materials wrongfully heaped up near the common passage and so on. Yes. Now, my written statement was that, shall I read the entire or
No, you just.
place the relevant?
We can place the we can see the facts from the appellate court's judgment. The trial court's
Yes,
judgment
yes,
is in
yes,
Hindi,
it is there.
right? It is
But
concurrent
before-
finding.
But before it is that appellate court's judgment is seen, I'll only play the leader commissioner's report may be seen, because that would clarify the entire suit property.
लाइए जरा रिकॉर्ड दीजिए.
And that is not in challenge by either of them. He had only disclosed what was there in the
What
facts.
was the exhibit number?
Exhibit E. Exhibit C is the
Report.
and the report is exhibit E.
Yes, it's there. Yes, please.
Before this typed portion is read, map is there in the second page that we see. At the top is Hari Kishun Shah name, and after that, the portion which has been marked A, B, C on the left side, if A portion it belongs to the plaintiff. And this was the portion that was donated by the original donor to the plaintiff. And it contains 3 rooms, room number 1, room number 2, room number 3, and it has separate entry and exit doors, door and window on the roadside itself, on the main road. And it has staircase also on the right side. There is another lane which is there on the right side. And there is a staircase in their own property for going over to the rooftop, their own. This belongs to the portion marked as exhibit marked A belongs to the plaintiff. Now the property which was sold to me has been marked as exhibit mark B. It starts from this portion B has been sold to me.
This is defendant.
Defendant. And D to E, that means D to E is a boundary between us. That means dividing the property between the plaintiff and the defendant. D and E is the demarcating line.
Boundary.
Boundary.
Well defined.
Yes.
It is one building.
No, 2 separate buildings, but it is absolutely connected to each other.
Okay.
And on the Mark C is the another property which not in dispute. It was gifted by the original owner to another son. So this is not in dispute. This belongs to.
Which is the area which is in dispute?
Yes. Now they say plaintiff's case is that from Hari Krishna Sao Lane there is gully on the right side.
Yes.
And this gully they have a right to go. This gully is not in the suit property. After gully, they have a right to enter into my house, this passage. Passage word has been mentioned. On the lowest portion of my mark B, just before mark C. G after
passage,
G.
passage.
Yes, passage has been mentioned.
Yes.
They have a right to go to the passage, to the stairs, and above my roof, and then they want to go to their own house, which is between D and E. This is their basic claim. So they say they have a right to go to passage, to take the stairs, go over my roof, and then access their own house. This is the entire claim. Now the pleader commissioner reports that there is absolutely nothing here between D and E. There is no opening of land. And now, can I read the portion?
A report.
Yes.
Read the report.
Started local inspection of disputed suit premises on 13 so in presence of Ganesh Thakur, plaintiff, and Radheshyam Tiwari, husband of the defendant. The premises is butted and bounded as follows. House of Jagdish Kesri. This may be seen from the map. The northern side is towards the mark A. On the left side is the northern side. There is a house. And then on the south is the gully. That means right side is the gully. Right side is the south. And then east is Hari Kushum Sa Lane. And west is the house of Govind Thakur, who is another, whose portion has been marked as Mark C. That is house of a third person, Govind Thakur.
No, this is the boundary of the entire premises.
This
You see, it is shown as the boundary of the plaintiff.
no, it
House of Govind Thakur.
yes, it shows that the entire A and B is surrounded as follows. This is what he is saying. Entire A and B, the boundary is of entire A and B. He
The
does
premises.
not, he only says the premises is butted and bounded as follows. He does not say suit premises. but this boundary is of conjointly A and B. In this house, both plaintiff and defendant reside in separate portions. Portion marked A shown in the rough sketch map is in occupation of the plaintiff. Mark B shown in rough sketch map is in occupation of the defendant. According to writ D to E, wall shown in the rough sketch map is in dispute. This wall is the west to the house of the plaintiff and east to the house of the defendant. This wall separates the house of the plaintiff from the house of the defendant. Point 1 of the writ. There is no sign of passage, therefore the use of passage does not arise. Point 2 of the writ. I do not find any door and window fixed in DE wall, which is the west to the portion of the house of Ganesh Thakur. However, mark E shown in rough sketch map, it appears to me that previously there may be either door or window. But presently DW wall is through D to E. Portion 3 of the writ, eastern wall of the house.
DW कहाँ है? DW. Where is W?
Is through DW नहीं है, ये wall through D to E. D to E के बारे में बोल रहे हैं. लेकिन why he has mentioned DW
Point 3.
हाँ, it wall is through D to E. This is what is. Point 3 is the eastern wall of the house of Ganesh Thakur. The plaintiff have 3 doors and 3 windows opening on Hari Kishun Shah Lane. The thread said 3 doors and 3 windows are respectively of the 3 rooms marked as a mark 1, 2 and 3. That means 3 rooms. This is the report of the
This is
So-
exhibit number C. Exhibit E.
Exhibit. So, from this, my contention would be that the original gift deed may have contained a right to given to them to access, but ultimately that property was sold out, and they have directly access to the road itself, and they have
How do you say, what was the access provided
access provided.
to this disputed property passage? It was only access provided to the passage and the staircase.
Yes.
How do you say that now they want to cross your terrace?
Yes, because
Terrace is also included?
no.
If terrace is not included, that is not required.
Then,
See, as per the deed,
yes.
as per
No.
the deed, you see, now they have access to all gully and lane and everything. As per the deed, they have an access to the passage and the staircase, right?
Yes.
Now, if they have an access to the passage and the staircase, then they will have an access to the passage and the staircase. They may keep their scooter, they may keep their vehicles. You do not know such property are of multiple use.
It is so unreasonable on the part of the defendant. How the plaintiff is misusing. Now he has direct access to both road as well as he has also made staircase in his own house. Now he wants to go to
No, there is
my
no,
property, he wants to go
there
to his
is
own.
no access provided to the terrace as per the deed. Whatever is provided as per the deed, it's okay. Only that will be retained. What else? है ना? उसके beyond तो नहीं मिल सकता.
इसमें एक छोटा सा बात था, ये क्यों हुआ ऐसा? ये जो कॉमन प्रॉपर्टी था, इनकी मदर का कॉमन प्रॉपर्टी था, और
वो भी था property.
therefore the arrangement was made in the year 19.
नहीं, is it mentioned in the deed that you will cross the terrace and approach your terrace? ऐसा तो नहीं है. अब प्रॉब्लम क्या है कि at that point of time, जिस वक्त ये डीड बना होगा आपका डीड, उस समय एक ही टेरेस रहा होगा, एक ही स्टेयरकेस रहा होगा.
एक ही इंसान का घर था दोनों.
एक ही इंसान का दोनों घर था, तो एक ही छत था, एक ही सीढ़ी था. लेकिन उसमें कहाँ लिखा है कि सीढ़ी मतलब अपने एरिया को एक्सेस करने के लिए यू विल क्रॉस द टेरेस आल्सो? Is it mentioned in the deed? Is it mentioned in the deed?
क्या है must be very clear.
उस जमाने में एक ही रहा होगा ना?
वही एक ही था, वही हम बता रहा हूँ,
वही-
पढ़ दे रहे हैं, उसको पढ़ दे रहे हैं, एक लाइन पढ़ दे रहे हैं, जो विवरण जायदाद इनका गिफ्ट डीड का है।
कहाँ है बताइए एग्जिबिट नंबर?
हाँ, एक बार exhibit 1.
Exhibit 1.
हाँ बताइए एग्जिबिट 1 है, साथ में मैप है, यही तो है दो एग्जिबिट इनका।
विवरण जायदाद में ये डिस्क्रिप्शन।
यू जस्ट कम टू द मैप,
अच्छा,
पहले मैप से ही पता चलेगा। You have the private lane, you have this lane, you have 3 rooms over here, right? And this is passage. पहले ये जो पोर्शन था ना पैसेज, उसके उधर लैंड था तारा देवी, देयर वाज नो
और
कंस्ट्रक्शन,
डिवीजन
वेकेंट लैंड होगा। यू जस्ट सी द
मैप
मैप,
मैप
हाँ मैप जरा देखिए। मैप में देयर वाज जस्ट अ लैंड ऑफ तारा देवी, इधर भी लैंड ऑफ तारा देवी, ये लैंड वरेंडा रूम, इनका मैप देखिए, है आपके पास?
हाँ मैं देख
इसमें पैसेज दिख रहा है, उसका लैंड ऑफ तारा देवी दिख रहा है,
हाँ।
ऊपर लैंड ऑफ तारा देवी दिख रहा है,
हाँ जी
उधर इधर लैंड ऑफ तारा देवी दिख रहा है,
हाँ।
इधर वरांडा दिख रहा है, उधर एक रूम दिख रहा है। ठीक है?
ठीक है
अब लैंड ऑफ तारा देवी डज नॉट बिलोंग टू तारा देवी एनीमोर. Now the construction has come up as per the new.
हाँ आफ्टर सेल
After sale इतना construction हो गया उसमें.
हो गया
ठीक है. Now they have exclusive right title over that property. तो आप छत से कैसे पार करना? पैसेज जो है आप यूज करिए, आपको जो भी यूज है आपको पैसेज आप करिए, है ना? बताइए.
हमको कल के लिए इसमें एक बार
कल क्या अभी यहाँ पे सुन रहे हैं तो टाइम देने के लिए थोड़ी सुन रहे हैं. अब ये देखिए,
अपीलेंट का आर्गुमेंट आज के लिए मेरा कल को लग गया है बिकॉज़ नॉट आई हैव रिसीव्ड बगल को लेटर डेट आई विल नॉट बी एबल टू असिस्ट योर लॉसेस.
हम आपको बोले थे ना आपको टाइम चाहिए तो हम आपको टाइम दे देंगे सब्जेक्ट टू कॉस्ट. यू डिड नॉट अवेल दैट.
सिर्फ कल के लिए हम कह रहे हैं कि हमारा आर्गुमेंट कल सुन लिया, हम सुनने के लिए कह रहे हैं कल को हम का समय काफी कीमती इसीलिए हम बोले कि सुन लिया जाए, लेकिन हमारा आर्गुमेंट कल सुन लिया जाए.
तो मेरा समय अगर कीमती है तो आधा घंटे से मेरा समय क्यों बर्बाद कर रहे हैं? What is the finding? The right to passage has been denied.
Because it is mentioned in the deed, therefore my entire contention has been, and it has been said that though it is not applicable, but it is applicable in the Sarkar. That is completely against the.
It is applicable in Santhal Pargana.
That is the finding of the appellate court. What it says is, why it is applicable? Exactly the lines are para 30.
ये जरा डीड पढ़िए तो.
कितना?
ये जो गिफ्ट डीड है.
Deed.
What is the right which has been?
मेरे पास टाइप है.
पढ़िए.
I am reading from it. विवरण जायदाद से पढ़ रहा हूँ. दानदाता दान ग्रहीता है. दानदाता is मुसम्मत तारा देवी. दान ग्रहीता is गणेश ठाकुर. And दान पत्र है और विवरण जायदाद. थाना 413 सो मौजा श्यामगंज के अंदर मुंशी मुखरारी सत्व की बसौड़ी जमीन टाउन प्लॉट नंबर 507A/8 का अंश 334 वर्ग फीट में उस पर पक्का का एक कमरा वो एक बरामदा में दात्री के कॉमन पैसेज आंगन वो छत पर जाने का सीढ़ी का व्यवहार करने का.
छत पर जाने का
नहीं छत पर जाने का बट सीढ़ी को व्यवहार करने का.
छत पर जाने
नॉट
छत है कहाँ? See the map.
उस समय नहीं था वो छत था.
नहीं है ना, मैप में ही नहीं है.
डीड में छत पर जाने का लिखा है उधर सीढ़ी.
आप जरा देखिए ना.
सिर्फ सीढ़ी है.
You just have a look at the map. You just have a look at the map. ये पैसेज दिख रहा है. Just look at the passage. इनको दिखाइए ना मैप, इनको मैप दिखाइए. ठीक है, ये पैसेज दिख रहा है. इसमें छत बोल के कोई चीज दिख रहा है? सीढ़ी दिख रहा है? नहीं दिख रहा है. उसके बाद ऊपर दिख रहा है लैंड, नीचे दिख रहा है लैंड, दाहिने और दिख रहा है लैंड. एक वरांडा और एक रूम आपको दिया गया है.
जो रूम है तो रूम के ऊपर जो रूफ है वो तो छत ही है.
नहीं तो ये पैसेज से यहाँ छत पे कैसे चले जाएंगे?
बरामदा से छत पे जाने का, बरामदा से रूम के ऊपर.
ये बरामदा, ये जो पैसेज है, ये पैसेज तो यहीं पे टर्मिनेट कर रहा है ना.
ये राइट साइड में जो पैसेज, राइट साइड जो पैसेज है, राइट साइड से एंट्री होकर के जो बरामदा है वहीं पे तो वो सीढ़ी है.
राइट साइड ये जो
पैसेज है राइट साइड में.
ये जो पैसेज दिख रहा है, पैसेज से सीढ़ी किधर है?
सीढ़ी के बरामदा के बगल में उधर बरामदा के से उठ करके वो जो बगल का रूम है उसमें सीढ़ी जा रहा है। रूम का जो भी रूम होगा उसके ऊपर तो उस तो छत ही होगी। रूम के ऊपर जो भी कंस्ट्रक्शन होगा
सीढ़ी तो
हम
इस मैप में कहीं है ही
नहीं
नहीं।
हम क्लैरिफाई कर दे रहे हैं। इफ ही इज रेफरिंग टू द म्युनिसिपल रोड
सीढ़ी
एंट्री
तो
थ्रू
वहाँ-
म्युनिसिपल रोड, तब तो ये मेरे पीछे आने का कोई जरूरत ही
सीढ़ी
नहीं।
तो जो
ये तो मान रहे हैं कि गली में घुस के हमको
लीडर
मेरा
कमिश्नर का जो अभी पढ़े रिपोर्ट उसमें स्पष्ट दिख रहा है।
उसमें सीढ़ी है, इसमें सीढ़ी नहीं है ना।
लेकिन
ये आपका गिफ्ट डीड का मैप है जिसमें सीढ़ी नहीं है, और ये पैसेज के अगल बगल चारों तरफ लैंड दिख रहा है। इसको क्या समझे हम?
जो गिफ्ट डीड में स्पष्ट उल्लेख है सर, अभी पढ़े कि
तो कौन सा सीढ़ी? सीढ़ी तो है
सीढ़ी
नहीं।
बताइए ना, कहाँ है आपके मैप में सीढ़ी? There is no staircase.
there is a description below.
डिस्क्रिप्शन मैप है ना साथ में। बताइए इस मैप में सीढ़ी कहाँ है? लैंड है और ओनली वन रूम ऑन बरंडा दिख रहा है।
The deed is to be read as a whole, below.
हाँ, deed is-
सिर्फ इसको इसका कंटेंट्स को भी देखना है। कंटेंट्स में जिस बरामदा का जिक्र है, मान लेते हैं कि अगर दो बरामदा होता और उसमें अगर ये नहीं होता सीढ़ी दोनों में से, तो इट वुड बी वेरी मच डिफिकल्ट टू आइडेंटिफाई किस दो में से एक में सीढ़ी है। बट बिलो यहाँ एक ही बरामदा है और एक बरामदा का जिक्र करते हुए डीड का कंटेंट्स में है कि देयर इज अ सीढ़ी, इट मींस द ओनली बरामदा।
There you see it's a gift deed, unilateral act, right? Right? It's a gift deed.
Yes,
right? इस मैप में कहीं भी आपके सीढ़ी का कोई जिक्र नहीं।
हम वही कह रहे हैं।
And we do not know which staircase are you using.
Yes, madam.
And where is the staircase?
Yes, madam. Yes, madam.
Where is the staircase?
Therefore, madam, I am saying इसमें एक जगह जो भी सर पर्सन ये इसमें 1 मिनट देखा जाए। इसमें जो अभी सर पढ़े का आंसर रखवा 334 वर्ग फीट में उस पर पक्का का एक कमरा जो मैप में है और एक बरामदा मैप में है बरामदा। मैं दानदृत के कॉमन पैसेज आंगन व छत पर जाने का सीढ़ी।
लेकिन छत पे जाने का सीढ़ी आपके मैप में कहीं है ही नहीं।
हाँ हुजूर, हम मान लिए कि उसमें नहीं है।
हाँ तो?
लेकिन हम इसीलिए कह रहे हैं कि द डीड इज टू बी रीड एज ए होल। सिर्फ और सिर्फ मतलब सिर्फ नक्शा को सिर्फ नहीं देखा जाना चाहिए इन एब्सेंस ऑफ मतलब अगर वहां सीढ़ी नजर नहीं आ रहा नक्शा में, इट इज टू बी रीड विद द कंटेंट्स ऑफ द डीड टू।
आप हमको ये बताइए यहाँ का पैसेज कौन सा वेकेंट लैंड में सीढ़ी बना दो? लैंड दिख रहा है ना,
बरामदा में है हुजूर।
There is-
इस डीड का कंटेंट्स के हिसाब से
ये पैसेज से बरांडा तक जाने का क्या एक्सेस है? पैसेज से बरांडा तक जाने का?
यस योर लॉर्डशिप, ये जो राइट साइड में जो पैसेज है हुजूर, राइट साइड में एंट्री के जस्ट राइट साइड में उधर से आने के जस्ट उसके राइट में तो बरामदा है हुजूर, जो कि लीडर कमिश्नर का हुजूर इसमें भी नजर आ रहा है सीढ़ी। ये बरामदा है, देयर इज ओनली वन बरामदा। अगर इट वुड बी वेरी मच डिफिकल्ट या फिर असरटेन नहीं हो पाता कि कौन सा बरामदा, अगर दो बरामदा है तो यहाँ सिर्फ एक ही बरामदा है और एक ही रूम है और वो डीड में वहाँ स्पष्ट बोला है कि उस बरामदा में से सीढ़ी का
There is a substantial change in the existing structure than what was there at the time of execution of gift.
Yes,
Right?
it was there, the contents.
There is directly from the passage, there is no question of any staircase. Reason being that the passage is surrounded by vacant land. The passage is surrounded by vacant land.
Madam, the contents of the deed said that there was a lot a
कहाँ?
staircase
आसमान में?
in the veranda, the only veranda, which is very much evident from the lot the naqsha itself appended with the deed. वो उसमें स्पष्ट कह रहा है और वो सिर्फ जो जब 2002 के बाद जब केस होता है subsequently when the leader commissioner has appointed, he has specifically said that this is the disputed area, this is the staircase for which the whole dispute has arisen between the parties, and not the dispute has arisen in the year 2000 itself when these defendant has purchased the land. Now look, ये जो बेची है वो माँ है और एक अपनी दूसरी बहू को दी और प्लेंटिफ को दी जो एक बेटा है। तो हुजूर इट्स वेरी मच एविडेंट कि जब वो कॉमन घर था एक ही फैमिली का था, सो देयर वाज एन कॉमन अरेंजमेंट। जब वहाँ पे एक ही बरामदा है और जिक्र कर रही है
The previous sale deed is not reflecting any.
यस इसमें एविडेंस एक्ट में एक जगह इस तरीके का ये है हुजूर कि if
फाइंडिंग दिखाइए, ट्रायल कोर्ट का फाइंडिंग दिखाइए।
यस
फाइंडिंग ऑफ फैक्ट ऑफ द ट्रायल कोर्ट।
हम एक बार हुजूर हम खाली कुछ नहीं बोलेंगे, हम एक बार पैरा 13 ऑफ द एपिलेट कोर्ट खाली एक बार पढ़ लीजिए पैरा 13 ऑफ द एपिलेट कोर्ट। The chronological list of enactments, para 13 of the appellate court judgment. The chronological list of enactments relating to the easement which are forced in India included the Indian Limitation Act, repealed by Limitation Act 1963. As per the provision of Section 21 of the Limitation Act, easement includes a right not arising from contract by which one person is entitled to and appropriate for his own profit and part of the soil attached or the land of another. Section 25 and 26 of the Limitation Act prescribes the acquisition of easement by prescription in the states where the easement does not apply. The acquisition of easement by other modes and the extent, incident, extinction and disturbance of easement are not affected by the Easement Act and are governed by the principle of English law as it stood before the Prescription Act of 1882 in England, where the application of such principle is situated to the usage and habits of the people on the well-known principle of justice, equity and good conscience. As such, I come to the conclusion that the law relating to easement is also applicable in the Santhal Parganas.
That pause it for a moment. It means that it is applicable in the concept of
Principle.
justice, equity and good
Yes,
conscience. Now there is no dispute on that.
Therefore, now Exhibit 1 is the registered gift deed with respect to 33 square feet of land executed by Tara Devi in favor of the plaintiff Ganesh Thakur. Although the defendant has pleaded in her written statement that gift deed has been written in Bengali language and Tara Devi had no knowledge about the contents of the gift deed, the defendant has not adduced any evidence in support of the fact that the gift deed executed on 6/7/1981 is a forged and fabricated document. As such, I come to the conclusion that the gift deed dated 6/7/1981 executed by Tara Devi in favor of the plaintiff Ganesh Thakur is genuine document. After perusal of the contents of Exhibit 1, it clearly transpires that the Tara Devi has gifted 334 square feet of land, included a pakka room and a veranda, this veranda, along with the donor's common passage, and the right to use the staircase situated in a courtyard to reach the roof in the favor of the Doni Ganesh Thakur, which is the plaintiff in this case. Exhibit A is the sale deed which was executed by Tara Devi in favor of Krishna Devi on 8/9/1981, and after perusal of Exhibit A, it transpires that nothing has been mentioned in the sale deed regarding the usage of donor's common passage and usage of staircase as mentioned in the gift deed executed in favor of the plaintiff on 6/7/1981. It has not been mentioned in the sale deed by the executor Tara Devi that the gift deed has been revoked. As per the provision of Section 126 of the Transfer of Property Act, a donor and donee may agree that on the happening of any specified event which does not depend on the will of the gift shall be suspended or revoked, and save as aforesaid, a gift cannot be revoked. The sale deed has been executed by Tara Devi in favor of Krishna Devi on 8/9/1981. After the lapse of 2 months after execution of the gift deed, the gift deed should have been revoked by the consent of the donor Tara Devi and Doni Ganesh Thakur, and through a registered document prior to the execution of the same deed by Tara Devi in favor of the Krishna Devi, if the appellant defendant wished to deprive the plaintiff the usage of usage and staircase, but since it has not been done in the present case, I am of the opinion that the subsequent transaction, execution of the sale deed in this regard is void. The appellant have filed the judgment delivered by Honorable Madhya Pradesh High Court in Thomas, so and so, AIR so and so, whereas alternative way was available to the plaintiff to approach his house apart from the said passage and the element of absolute necessity was absent. The Honorable Court held that the easement of necessity will not be granted when alternative passage is available. The appellant has also filed the decision of the Honorable Supreme Court passed in Justina Ananto and others versus Srimati so-and-so, where in the plaintiff had not proved uses access to the house as of right through property of defendant for more than 20 years, and moreover the plaintiff had access to the house of southern side which was being used by her for a long time. It was held by the Honorable Apex Court that the claim as to right to access to property of defendant was not tenable. But in the present case, the situation is quite different, and the plaintiff respondent has been granted right of usage of the common passage. The donor Tara Devi will also right to use the staircase situated in the courtyard to go on the roof through the gift deed dated 6/7/81, and the aforesaid registered gift deed has not been revoked prior to the execution of the sale deed dated 8/9/1981. DW7, being the son of the appellant, has stated in para 29 of his cross-examination that he does not have any knowledge about the injunction granted prior to the closure of passage by him on 18/11/2000, closure of passage. Thus, it becomes clear that the appellant has closed the usage of common passage by the respondent plaintiff, and I am of the opinion that the same is illegal in view of the terms of the gift deed dated 6/7/1981, executed by Krishna Devi in favor of the respondent plaintiff. Thus, in view of the pleading made by both the parties, the oral and documentary evidence available on the case record and discussions made above, I find and hold that the plaintiff respondent was granted right of easement to use the common passage and use the staircase situated in the courtyard to go on the roof by gift deed dated 29/21 dated 6/7/1981. I further find and hold that the right of easement granted to the plaintiff respondent has not come to him due to the execution of said deed dated.
Now let us say the staircase is situated in the courtyard, right? As per the new map which has come up, is there any staircase on the courtyard? There is no staircase in the courtyard. You have a separate courtyard to go to your terrace. Now they have a separate courtyard to go to their terrace. Is there any, if you want to go to the courtyard, right? आप लोग का अपना दीवार तोड़कर जो है ना, आपको उनके घर में घुस के कोर्टयार्ड में जाना पड़ेगा, क्योंकि you want to use the staircase situated in the courtyard. There is no staircase situated in the courtyard now, as per the map. Is there any staircase?
As per the baranda, as per the contents of the deed.
बरंडा में कहाँ है courtyard? As per the this report, there is no staircase in the courtyard now.
ये जो गिफ्ट डीड है,
गिफ्ट डीड की बात आप छोड़िए, अभी जो प्रेजेंट इंस्पेक्शन रिपोर्ट आया है, इज देयर एनी terrace, any staircase in the courtyard? You just see one thing. You are in the, आप खोलिए जरा इनका वो इनका जो मैप आया है, ठीक है? पूरे मैप में, पूरे बिल्डिंग में एक ही स्टेयरकेस, दो स्टेयरकेस दिख रहा है, करेक्ट? There are two staircases. हाँ, डिप्टी कमिश्नर, वो कमिश्नर का रिपोर्ट देखिए. दिखाइए भाई, इनको नहीं पता चलता, ठीक है? इसमें दो स्टेयरकेस है. एक स्टेयरकेस है पैसेज के साथ. आपका केस क्या है? आपको कौन सा स्टेयरकेस मिला था? स्टेयरकेस इन द वरांडा, राइट? ये तो स्टेयरकेस इन द वरांडा नहीं है. और दूसरा, आपने अपना स्टेयरकेस बना लिया है. आपने वरांडा वाला स्टेयरकेस को हटाकर अपना स्टेयरकेस बना लिया है टू गो टू द टेरेस.
हमने वरांडा का स्टेयरकेस नहीं हटाया,
मैप में नहीं है.
हमने बरामदा का स्टेयरकेस
मैप में नहीं है. It is not there in the map. In the map, there is no staircase in veranda.
यस मिलर.
Yes.
इसलिए यहाँ पे ये इनको ये नहीं आ रहा है. ये इट वाज मेड बाय लीडर कमिश्नर और इसमें फाइंडिंग है कि इट वाज क्लोज्ड. दैट वाज क्लोज्ड.
बात ये नहीं है. You want to use a staircase.
Yes.
Passage पे तो कोई बात नहीं है. You can have both can have access on passage, right? Okay. But so far as this staircase is concerned, there are only two staircases as per the map. One is the staircase which is just adjoining to passage, right? जब गिफ्ट हुआ था उस वक्त तो वहाँ staircase नहीं था. Staircase था बरंडा में, which is separated from this passage,
यस.
right? तो बरंडा में था staircase.
Yes.
अब बरंडा में तो कोई staircase ही नहीं है.
यस. यस योर.
दूसरा staircase कहाँ है? ये है.
यस योर. तो इसको ये प्लेन से स्पेसिफाई होगा बिकॉज़ मिलर
प्लेन से क्या स्पेसिफाई? फाइंडिंग से स्पेसिफाई हो रहा है.
नहीं.
Finding is that as per the gift deed, you were entitled to use the staircase in the veranda. Now there is a staircase in your property.
यस योर. यस. ये इसलिए हम बोल रहे हैं कि ये प्लेन से एस्टेब्लिश होगा क्योंकि हम कह रहे हैं कि वहां पे था लेकिन दे हैव क्लोज्ड इट. Once it has been closed and I have filed a case, thereafter a report has been prepared. So report is likely to prepare that there was no staircase because they have dismantled it or they have closed the access to it. The leader commissioner did not enter the veranda. How he would see not that there is a staircase?
Leader commissioner's report is not in dispute, nor there is any substantial question of law framed to that effect. There is no substantial question of law framed to that effect.
This point
And as per the gift deed, there was a staircase in the veranda,
Yes.
which you were entitled to use.
Yes.
The veranda is in your occupation. अरे correct? veranda तो आपके पास है ना?
अभी उसी में तो ये लोग ये कर दिए ना और तभी ना हम केस फाइल किया.
बरंडा तो आपको क्या मिला था? प्रॉपर्टी आपको एक रूम मिला था और बरंडा मिला था. और आज के दिन में जो आपके ऑक्यूपेशन में है वह रूम है और वो बरंडा है जहाँ पे आपने रूम बना लिया है. इट इज योर रूम. इट इज इन योर ऑक्यूपेशन. यू जस्ट सी. ये रूम था, उसके साथ एक ये बरंडा था जिसको आपने रूम में कन्वर्ट कर लिया है. एंड देयर इज वन मोर रूम. नाउ दिस बरंडा हैज बीन कन्वर्टेड इनटू अ रूम.
नो मिलो.
यस.
नो मिलो. ये जो मार्क ए है, मार्क ए is the house, the plaintiff's house, mark A. And जो B है जहाँ पे कोर्टयार्ड दिखा रहे हैं, जो बरामदा है मार्क B में है, राइट साइड.
आप प्लेंटिफ है ना?
Yes.
हाँ देखिए.
That is in defendant's occupation. That comes in the occupation.
No.
Yes.
Mark A is in occupation of the plaintiff.
Yes.
Entirely.
Yes.
Right?
Yes.
ये रूम है.
Yes.
उसके बगल में एक रूम और है.
हाँ.
उसके बगल में एक रूम और है.
हाँ,
और वहाँ पे
जिसमें स्टेयरकेस दिख रहा है.
जिसमें स्टेयरकेस दिख रहा है.
Yes, Your Honor.
पूरा का पूरा A portion is in your occupation.
Yes, Lord. ये जो A पोर्शन है हुजूर, इस A पोर्शन में ये जो कोर्टयार्ड है, that is not included. That is included in mark B. That is in the defendant's occupation.
He has to place the gift deed map like this, so that the road is on the top. Now
Yes.
both may
हाँ,
be
वैसे
seen like this. The road is on the top. Plaintiff's room number 1, 2 and 3 in the pleader
Yes.
commissioner's report. It is there. And here in the old gift deed,
Yes.
room, then
Yes.
veranda and then land. In the gift deed.
Yes.
So
ये बरंडा का
yes.
लोकेशन कहाँ पर है?
हाँ, इसी के लिए Your Lordship is right that it was allotted. It was the veranda was transferred to them, and they have now constructed a room in that. That is the room number 2.
Yes,
in
that
the
is room
pleader
number
commissioner's
2
report.
in the pleader commissioner's report.
Earlier it was veranda, but now they have constructed a room on that, which is room number 2. It would be better if this is placed like this. If both the maps are placed like this. The road, main road is on the top. Yes, it has to be placed like that. Then only the road Harikishan Shah Lane is on the top.
Hari Kishan Sah Lane.
Which has been mentioned as municipal road in the old game.
Yes, yes.
That
This
is
this is on the right now.
Yes, right.
Gully is at the bottom.
And then no, gully.
Gully is at the bottom.
Then your lordship has to place the pleader commissioner's report like this.
Yes, I've kept it like this.
Yes.
Leader commissioner's report when I put it like this.
Then
Gully is at the bottom.
gully is on the
Right.
bottom then.
Yes.
And the road, municipal road which has been referred in give deed now is being referred to as Hare Kishun Shah Lane in the
Yes.
pleader commissioner's
That's
report.
right.
Is on the right, and the property which was gifted to them was on the right end of the property.
Yes,
just
right
adjacent
end
to
room.
the-
Room.
Yes, room and then veranda
Room, then veranda.
and then vacant
Land. Vacant
yes,
land.
vacant.
दिख रहा है?
And then entire rest property.
मैच करिए दोनों का। ये जो वरंडा है जहाँ पे स्टेयरकेस है ये पूरा प्रॉपर्टी आपके ऑक्यूपेशन में है। This entire property is in your occupation as per the pleader commissioner's report. वो वरंडा में आप क्या कर रहे हैं वो आप जानिए।
एक उनको एक छोटा सा समय दे दीजिए कैलकुलेट आई नीड टू क्लैरिफाई फ्रॉम माय क्लाइंट।
आपके क्लाइंट क्या है इसमें क्लैरिफाई करिए। मैप दिख रहा है ना तो आपके सामने।
जो अपीलेट कोर्ट का जजमेंट भी है उसमें इस कोर्ट यार्ड का ही जिक्र हो रहा है।
भाई अपीलेट कोर्ट का जजमेंट में एरर है तभी ना सेकंड अपील एडमिट होकर पड़ा हुआ है। तो अब अपीलेट कोर्ट का जजमेंट
एक छोटा सा इसमें जो सब्सटेंशियल क्वेश्चन ऑफ फ्रेम ऑलरेडी फ्रेम्ड है उस सब्सटेंशियल क्वेश्चन ऑफ लॉ में कहीं पे भी ये बरामदा का ये इधर है या इधर है इसका नहीं तो आई वाज नॉट रेडी माय सेल्फ ऑन दैट पॉइंट। अगर होता हम पढ़ के आते हम पूछ के आते।
सुनिए एक चीज आपको बता दे रहे हैं ये बात करना बंद कर दीजिए। आपको शुरू में ही बोले थे टाइम चाहिए हम आपको कॉस्ट लगाएंगे आपको टाइम दे देंगे।
यस योर लॉर्डशिप बट इन दिस
लेकिन अब आप ये नहीं बोल सकते हैं कि हमको समय मिलता तो हम पढ़ के आते हम देख के।
नहीं वो नहीं कह रहे हैं आई एम सॉरी ब्रदर हम वो नहीं कह रहे हम कह रहे हैं कि इस सब जो बरामदा का पॉइंट है इसमें मुझे सब्सटेंशियल क्वेश्चन ऑफ फ्रेम नहीं था मुझे अगर वो फ्रेम होता तो हम उस पॉइंट को चाहे छोटा ही कम से कम
आपका ईजमेंट राइट थ्रू पैसेज is a subject matter of consideration. Now the point is that this easement right through passage तक तो easement right समझ आ रहा है लेकिन जो बरंडा जिस पर आपका staircase है right you had access to that veranda and that veranda is in your occupation.
इसमें जो एक बार प्रिंट का इसको देखा जाए हम इसमें स्पेसिफिकली बोले हैं कि वो जब वो सेल हो गया उनको जब जो सब्सिक्वेंट सेल से जब वो परचेज कर लिए परचेज होने के बाद जो हम कॉमन पैसेज उस बरामदा को कर रहे थे which is very much evident from my plate that it was not in my occupation it has come to the occupation through the sale lot according to lot the defendant तो defendant के पास चल गया तो वो मेरा
This veranda has not gone to the defendant. Defendant को जो property मिला है वो यहाँ पर है।
एक बार प्लेट देख लिया जाता है because the very basis उससे क्लियर हो जाएगा
उससे कुछ नहीं क्लियर होगा जब मैप है तो हमको प्लेन नहीं देखना। There is no error so far. It has not been pointed out कि मैप गलत है। है क्या ऐसा कोई केस है कि मैप गलत है?
प्लेन में हम स्पेसिफिकली बोले हैं हुजूर कि वो जो बरामदा इन क्वेश्चन है हुजूर, जो कि बरामदा ए बी सी में जो बी में दिख रहा है 1 2 और 3 जो 3 रूम है, जिसमें हम कह रहे हैं कि नंबर 2 जो है वो बरामदा
है ही बरामदा।
नहीं हुजूर,
हम क्या कह रहे हैं? मैप कह रहा है, हम लोग को थोड़ी कुछ कहना है।
इसमें
जो कहता है डॉक्यूमेंट कहता है, हम लोग कुछ नहीं कहते। आप इसको रिकंसाइल करिए दोनों, यही है।
इसमें हमको कल के लिए इसको रख दिया जाए। आई एम रेडी ब्लॉट, आई एम ऑलवेज रेडी ब्लॉट। इसमें अगर आज ये इशू नहीं होता कि बरामदा ही शिफ्ट करके रूम नंबर 2 में जा रहा है, आई वुड नॉट हैव टोल्ड यू ऑल्सो, बिकॉज़ आई एम ऑलवेज रेडी टू हम टाइम लेने वाले से नहीं बोलेंगे, लेकिन ऐसा सिचुएशन ही आ गया, आई वाज नॉट रेडी ऑन दैट पॉइंट ब्लॉट। आई हैव अल्टीमेटली आई हैव टू असिस्ट योर लॉर्डशिप ओनली बाय टुमारो ब्लॉट, 10 मिनट का है। अगर ब्लॉट
During the course of hearing, upon comparison of the map which is there, listen, Mr. Gupta. Mr. Gupta, please listen.
Yes.
ऐसे फिर गलत हो जाएगा ऑर्डर तो बोलिएगा गलत। During the course of hearing, upon comparison of the sketch map as furnished by pleader commissioner and the sketch map which is there in the gift deed, it transpired that as per the gift deed, there was one room over the property and a veranda, and the passage which is under consideration was surrounded by land. The appellate court has given a finding that the plaintiff was entitled to use the staircase situated at veranda through the common passage. Though the title of the passage or the veranda, though the gift deed was with respect to room and the veranda.
Yes.
Room and the veranda.
Room and
As per the pleader commissioner's report, the room which was gifted is existing, and the portion of upon comparison of map, the portion of veranda also has a room, and there is third area which is a room with an independent staircase constructed by the plaintiff, and the entire area, the 3 rooms including the staircase, is in occupation of the plaintiff. As per the gift deed, the common passage is not accompanied with the staircase. However, as per the pleader commissioner's report, there is a common there is a passage with a staircase, and the construction over B area is in occupation of the defendant, and apparently the staircase is to approach the terrace of the defendant. The pleader commissioner's report does not indicate existence of any staircase on the veranda. Since there is no staircase on the veranda, there is no question of any approach to the terrace through veranda. To this, the learned counsel for the respondent, yes.
And whatever staircase is there, it is there on the existing on their own property. It
Yes.
is already
The plaintiff and the defendant both have staircase
yes.
and have access to their terrace. To this observation of this court, the learned counsel for the respondent has strenuously submitted that the matter be posted tomorrow. Post tomorrow at 10:30 first case. नहीं आइएगा तो हम ऑर्डर लिखाना शुरू करेंगे, ठीक है? यही है आपका
हाँ
केस?
यही है, लेकिन एक सेक्शन 11 ऑफ टीपी एक्ट आल्सो आई विल प्लेसिंग ये एडवांस
नहीं बता दीजिए उनको पहले
फिर
से।
नहीं तो if let us assume that there was a condition repugnant to the interest created in my favor, the deed contained that I would not have absolute right on my property which was transferred to me. Then what section 11 of TP Act says, restriction repugnant to the interest created, where on a transfer of a property, an interest therein is created absolutely in favor of any person, but the terms of transfer direct that such interest shall be applied or enjoined by him in a particular manner, he shall be entitled to receive and dispose of such interest as if there was no such direction. That means I become the absolute owner of the property. And even if such direction is there, I am not bound by such. Only if it would have been, the second portion says, that if they would have a property which they would have access through my property and they could have not have used that property without, then there was some condition, then we might have.
No, when the staircase itself is not existing,
this
the
is
matter
additionally I
ends.
am saying. This is additionally I am.
So there is no question of any access to veranda
Now,
if that staircase is not existing.
and
over the
all
veranda.
these, their entire property itself is on the road, main road. Now, why do you want to go to the gully, to passage, to staircase and then?
वो जो पड़ोसी का जो ट्रेडिशनल
क्या
झगड़ा है वही है ये।
है, लेकिन मतलब कितना, therefore it is not, it does not qualify the words justice, equity and good conscience.
इसमें एक छोटा सा क्लियर था कि अगर if it can be Friday because
फ्राइडे नहीं, अभी तुरंत
क्लाइंट को अगर
हो गया ना आपका क्लाइंट का कहानी, सुन लिया ना, 5 बार आप बोल दिए कल के लिए रखने के लिए, अब जैसे ही कल रखे तो फ्राइडे, ये किस तरह का बिहेवियर है? इतना है तो अपने क्लाइंट को बोलिए आ जाने के लिए, कोर्ट में सुनेंगे अपना बहस, ऑनलाइन भी अवेलेबल है, सुन सकते हैं, ऑनलाइन ज्वाइन कर सकते हैं, ज्वाइन करा दीजिए उनको, ऑनलाइन ज्वाइन करा दीजिए, कोई बात नहीं।
नो हम क्लाइंट उसमें जो मैप में शेयर केस बिकॉज़
चलिए सुन लिए ना, हो गया बात। The learned counsel for the appellant has also referred to section 11 of the transfer of property. दो पड़ोसी मिलके कब का सूट है ये? हाँ? 2000 25 साल से लड़ रहे हैं। पूरा स्ट्रक्चर चेंज हो गया, कंस्ट्रक्शन हो गया, सब कुछ हो गया, अपना सीढ़ी बना लिए। आप ही बताइए, सोचिए थोड़ा सा, एज ए काउंसिल भी जरा सोचिए, अपने अपने छत पे जाने का सीढ़ी बना लिया, अब उनको इनके छत से होकर जाना। चलिए
Now serial number 6 under the heading final disposal SS 328 of 2016.
appellant, yes please, which is a substantial question of law. Non-consideration of issue involved.
Second is whether the court below have recorded finding beyond the pleading and evidence of the parties about identity of the suit property. And third is whether the appeal court below has recorded legally wrong finding at the instance of instance case number 105 of 8 to 19.
चलिए पढ़िए, argue please. Yes, argue. You are the plaintiff or the defendant.
For the plaintiff, is a plaintiff second thing.
Is it concurrent finding?
Yes, it is. Trial court has given a finding regarding.
ऐसा नहीं होता है, सेकेंड अपील इस तरह से बहस नहीं होता, you argue properly. Plain written statements चाहिए. I will give you not today. बिना cost के यहाँ not today नहीं होगा. यहाँ नॉट टुडे बिना कॉस्ट के नहीं होगा मिस्टर तिवारी। अब 20,000 से कम कोई कॉस्ट नहीं करेंगे। सुबह हम किए हैं 20,000 कॉस्ट, इससे एक पैसा आज किसी भी केस में कॉस्ट कम नहीं होगा। स्टार्ट।
This is plaintiff's second appeal.
Give me the records, please.
In this appeal, I filed one
IE for
for production of additional evidence.
additional evidence.
Additional evidence.
What is that IE about?
And in IA, the reply had also been filed.
Where is that IE?
IA number 761.
761. And what is the additional evidence you want to produce?
Additional evidence is the order sheet of case number 105 of 65. And reference of the same is also in the documents exhibited in this suit. And
You place your IE.
Rent was assessed on 8/2/1965 in the name of the predecessor interest of the plaintiffs. The case of the plaintiffs have brought the suit for declaration of right title in possession of the suit land for recovery of possession. The case of the plaintiff in the step is there are two sets of the plaintiff. The claim of the first set of the plaintiff is that their fathers, respectively namely Chandrika Dubey and Rajkishore Dubey, reclaimed about 10 acres of land in plot number 78, more than 3 acres in plot number 73.
Just a moment. What is the response to this IE? They have filed their response?
Response, there are 5 incidents.
Yes, kindly read the reply. Since they are not there, you have to read their reply also.
Needless case of the plaintiff.
No, you just the IE तो देखिए ना क्या? IE का reply.
IA, one document relating to the order sheet of the assessment of rent through case number 105 of 1965. By which the rent had been assessed. For that, the same documents having direct bearing on the monthly judgment and for substantial cause. The rent had been assessed in the name of the ancestor of the plaintiff first on 8/2/1965 through case number 105. And the document could not be marked after hectic efforts. The hard copy of the documents which was obtained from Mazia also, and the same copy filed for the medicine in this appeal. And these documents are very much essential for the effective adjudication of the matter involved in this case. But contrary,
The rent of the suit land in Schedule C was assessed in the name of Chandrika Dubey and Rajkishore Dubey, who are the ancestors of the plaintiff number 1. Right? Okay. Additional evidence can be seen only if there is a foundation in the suit. Let me see where is your case in the suit that this land, this property was assessed.
Yes. Then I'm referring paragraph 2
Of the
of the trial court judgments.
okay.
The brief of the plaintiff's case is that there are two sets of the plaintiff. The first set, less than and begun have claimed the property within plot number 78, area 10 acres, and plot number 73, about more than 3 acres, and plot number 96, about 1 acre, all within the village of Pili. Initially, recorded in many of the fathers, Sandika began the lien for the above land was assessed, and accordingly, corrections deed was issued on 8/2/65 in case number 105. This is the field. And since the date of vesting of intermediary interest into the state, rent was regularly realized from them. Both Sandika and so there is some other vast land, including 2 acres land plot number 97, and the rent for the same has already assessed, and they are paying rent. And they have been recognized as principal here by the state government, and after death of the father, their father is being exclusively heirs having inherited property in kind of physical cultivating information. Also, the 22nd state have reclaimed 1 acre of land in plot number 78, and their land has also been assessed and demand was opened by the state government to the year reality. Rent derived from him from the date of vesting of Yundari. In between the moment what happened on a very fine morning that we can without any just and cogent reason got initiated and proceeding in the ceremony to take before the team Brahma. Even the plaintiff nonetheless I miss case number 290 of 1986 in which the defendant has claimed that the land described in suit 3.
What was the suit property? Suit property.
That I can mention in the beginning. The description of the suit land is mentioned in Schedule A of the document. Schedule A comprises of Schedule B and Schedule C.
Why there are 2 schedules? Schedule. Okay, Schedule B and C is part of Schedule A.
Schedule A, part of it. Schedule B, claim of second set of plaintiff rests on Schedule B, and claim of first set of plaintiff on Schedule C, and both comprise within Schedule A of the plaintiff.
So now the plot numbers are 96, 97, 78 and 78. Now you say that the property in the rent was assessed in connection with this property in your name.
Yes.
Correct? Now show me from the additional evidence.
Plot number 96 mentioned, and plot number 78. There are batta plots because the same have been separately divided.
You see, the area is not matching, the boundary is not matching. How do we get that it was only this property which was there? Area भी matching नहीं है. अब मान लीजिए ये plot number है 96, ठीक है, 200 एकड़ का है, ठीक है.
That is
कैसे पता चलेगा?
That is of 27 acres, 27 and all.
No, we do not know what is the area.
That has been
Okay, 27 एकड़. दोनों का area matching नहीं है. इसमें कोई boundary नहीं दिया हुआ है. तो कहाँ से पता
But the
चलेगा?
basis of the claim of the plaintiff that the rent was assessed.
Maybe that was the basis of the claim, but it is not matching. आप additional evidence आप लेके आ रहे हैं. It is not matching. It is of no use to the court. इसके basis पे हम कुछ नहीं decide कर सकते.
But it is not the case that the same amount is assessed. Rent has been assessed.
No, rent have been assessed. It could be many parts of the property of the same khata number, same plot number.
What they are, I'm just coming on the findings, findings of the rent.
Yes.
If
It cannot be said that this property is the same property.
if the additional evidence is required for substantial justice.
No substantial justice. ऐसा घर में सोने वालों को कोई substantial justice नहीं होगी.
Because what happened in this case, the learned trial and the first appellate court both have traveled beyond the pleadings.
वो तो अलग बात है. हम additional evidence का कहानी पहले खत्म करें.
तो additional evidence अगर मुझे समझा जाएगा कि आवश्यक है, तब ये चूंकि there are three lists.
आवश्यक ही नहीं है, इसका रेलेवेंस भी आपने हमको सेटिस्फाई कर पाया. कोई रेलेवेंस नहीं है. आपका देखिए खाता नंबर 96 में यू आर क्लेमिंग एरिया 0.38, ठीक है. और यहाँ पर है एडिशनल एविडेंस में खाता नंबर 96 बटा 281, 96 बटा 255. It is 42 decimal. It is not matching. It is not matching.
96 बटा 281, 96 285.
ठीक है. अब ये कैसे पता चलेगा कि सूट प्रॉपर्टी इज अ पार्ट ऑफ दिस प्रॉपर्टी?
But what necessitates the plaintiff for instituting the suit because proceeding under section 144 CRPC was initiated over the
एडिशनल एविडेंस इस तरह से नहीं देखा जाता. एडिशनल एविडेंस पहला बात आपने प्रोड्यूस नहीं किया, इट्स योर फॉल्ट. Now the court will see whether the court requires this additional evidence to come to a finding.
That is upon the court.
It is not matching.
That is third link. Third link of the.
It is not matching. Not at all. It is not matching.
But the plots are matched.
प्लॉट नंबर मिलने से, रांची मिलने से क्या पूरा रांची हो जाएगा क्या किसी आदमी का? नहीं होगा ना.
Plots are matching 78 and rent has also been set in the name of.
Please hold on. Just IA number 7619 of 2023. This petition has been filed. The counsel for the appellant has commenced the hearing of this appeal. He has placed the interlocutory application seeking to adduce additional evidence and has submitted that the specific case of the plaintiff was, with respect to the suit land, the property was, the rent was assessed and correction slip was issued on 8/2/1965 in case number 105 of 1965. The learned counsel submits that the said document could not be produced before the learned trial court or even before the learned first appellate court by additional evidence. However, the same has been produced through the interlocutory application. He submits that for the ends of justice and for properly deciding this case so as to put the quietus in connection with the dispute between the parties, the additional evidence is necessary. However, during the course of argument and upon comparison of the suit property, it appears that the description of the suit property is as under, and the description of the property as mentioned in the additional evidence is as under. The counsel has referred to this court finds that the area is not matching and plot number 96 and plot number 78 have been shown in different parts, and there is a separate plot number 78. Prima facie, this court is of the view that the additional evidence may not be of any use to decide the dispute between the parties. चलिए आगे बताइए. अब सब्सटेंशियल क्वेश्चन ऑफ लॉ बहस करिए. अभी फाइनल ऑर्डर नहीं किए हैं आइए पर. मैचिंग नहीं है दोनों. That I have seen. I have just recorded it for my memory.
But it reflects that the rent has been assessed. Relatively.
How does that make a difference?
And through that case.
ठीक है, whatever is reflecting that is there. बताइए.
This substantial portion of law that has been framed in this.
जरा बताइए तो कल हम कितने मैटर्स रखे हैं पहले से. आज से तो एक गया है 10:30 बजे. It will not take much time. Yes, we are here. Substantial question of law. पढ़िए.
Whether the concurrent findings of both reports suffer from perversity due to non-consideration of the issue involved in this case, and on the basis of evidence, oral and documentary, reduced by the parties.
Just पहले तो ये पहला substantial question of law को explain करिए, क्योंकि बिना explanation के तो हमको समझ नहीं आ रहा. कौन सा issue है? कोई भी issue नहीं decide किया क्या कोर्ट?
नहीं, ये नहीं है. Whether the concurrent findings of both reports suffer from perversity due to non-consideration of the issue involved.
Non-consideration of the issue.
Involved in this case, and on the basis of evidence, oral and documentary, reduced by the parties.
तो issues जो frame हुआ वो गलत frame हो गया या issue जो decide हुआ वो गलत?
Issue गलत frame हुआ. And in one
issue ही गलत frame.
And in one consideration, the finding has been given.
Sorry.
In one consideration, the finding has been given.
Issues have been wrongly framed.
Wrongly framed. Issues have
क्या issue frame होना चाहिए था?
Issue frame होना चाहिए plaintiff के right title के interest में. Plaintiff having right title interest on. कोर्ट ने ट्रायल कोर्ट ने issue frame किया, defendant का issue frame कर दिया.
क्यों नहीं issue frame करेगा? Defendant अगर adverse possession claim करेगा तो issue तो frame करना ही पड़ेगा.
Defendant का उस तरह कोई claim रहेगा तो
वो अलग बात है. ऐसा नहीं है कि
कर सकता है उस पर नहीं. In absence of any counter claim.
नहीं adverse possession के लिए counter claim का जरूरत नहीं है.
तो वो करेगा, adverse possession plead करेगा, adverse possession करेगा.
वो अलग बात है. लेकिन ऐसा नहीं है कि defendant से related कोई issue frame नहीं हो सकता. है ना? आप हमको बताइए कौन सा इशू गलत फ्रेम हो गया और अकॉर्डिंग टू यू कौन सा इशू फ्रेम होना चाहिए. इतना आप लोग इस तरह से इतना वाइड आप लोग सब्सटेंशियल क्वेश्चन ऑफ लॉ बनवाते हैं, हमको तो समझ ही नहीं आता ये फर्स्ट अपील करवा रहे हैं कि क्या करवा रहे हैं.
सबसे इम्पोर्टेंट फैक्ट ये है कि ट्रायल कोर्ट हैज गिवन द फैक्ट रिलेटिंग टू इशू बाय क्लबिंग ऑल द इश्यूज द इशू नंबर and in one finding issue number 8, 9, 11, 12 and 13.
Just a moment. Now whether the court below have recorded a finding beyond pleadings and evidence, this is another substantial question. उसके बाद whether the appellate court below has recorded illegally wrong finding at the instance of miscellaneous case number such and such against a plaintiff number 2.
हाँ ठीक है.
ये तो exhibit ही नहीं हुआ था.
नहीं तो the first appellate court, the grounds for non-suit this suit of the plaintiff, that this document had not been brought, this document had not been brought.
That was the basis of your claim that the rent was assessed in your name.
But this was not the claim of the plaintiff second set. This was the claim of the plaintiff first set. First set. That's why this substantial question is very much important.
And the parties are at liberty. चलिए. अब जरा ट्रायल कोर्ट का पहले इश्यूज पे ही आते हैं कि इशू गलत है. फर्स्ट एपेलेट कोर्ट में ये पॉइंट रेज किए थे क्या कि इशू गलत हो गया? कि इशू गलत हो गया था.
फर्स्ट एपेलेट कोर्ट ने यही सिर्फ 2 पॉइंट्स पर कि आइडेंटिटी और प्रॉपर्टी पर फर्स्ट एपेलेट कोर्ट ने सूट को डिसमिस किया ऑन द बेसिस ऑफ आइडेंटिटी और प्रॉपर्टी एंड दैट द सेम इज हिट बाय अंडर ऑर्डर 7 रूल 3 when there is already the suit land is specified within the boundary. The boundary is mentioned, khata is mentioned, plot is mentioned.
Where are the issues framed?
Yes. Page 18.
Page 8.
1-8.
इसमें से अकॉर्डिंग टू यू कौन कौन सा इशू नहीं होना चाहिए?
हाँ. इन्होंने क्या है इशू नंबर
1. Is the suit as framed maintainable? Okay, चलिए इसमें कोई
उस पर कोई dispute नहीं.
Cause of action?
उस पर नहीं. Whether the defendants had added right at interest over the suit land.
Estoppel, waiver, acquiescence, limitation, adverse possession. इसमें भी आपको कोई डिस्प्यूट नहीं
उधर
है।
नहीं है। मेन है ये कि
मल्टीफेरियस कॉज ऑफ एक्शन।
whether defendant has valid right title, issue number 11 and issue number 30.
उससे पहले 10 है नेट का तो उससे पहले तो 10
हाँ तो ठीक है, हाँ 10 भी है।
प्लेंटिफ का राइट टाइटल एंड इंटरेस्ट डिसाइड करना था
हाँ मैंने
और डिफेंडेंट का भी राइट टाइटल एंड इंटरेस्ट डिसाइड करना था, क्योंकि डिफेंडेंट इज आल्सो क्लेमिंग टाइटल।
डिफेंडेंट क्लेम नहीं कर रहा है कोई किसी तरह का। डिफेंडेंट इसमें क्लेम अपना टाइटल कहाँ किया है किसी तरह।
एडवर्स पोजीशन क्लेम कर रहा है ना, एडवर्स पोजीशन भी नहीं
एडवर्स
claim कर
पोजीशन
रहा
सिंपली सीटर एक वर्ड है एडवर्स पोजीशन।
है। तो भी
एडवर्स
वो एडवर्स पोजीशन क्लेम कर रहा है। आर यू क्लेमिंग टाइटल? यू आर क्लेमिंग एडवर्स पोजीशन और टाइटल,
बोथ कैन नॉट बी साइमल्टेनियसली।
वो अलग बात है। आप बोल रहे हैं इशू गलत फ्रेम।
हाँ ठीक है।
वही उसी पर हम सोच रहे हैं कि क्या क्या इशू गलत फ्रेम, which issues have been wrongly framed.
I mean, my submission before you already see that the learned trial would cloud all this without deciding the separately.
That is not the substantial question of law.
हाँ नहीं।
तो जो नहीं है उस पर मत बहस करें।
And in one consideration, the
आप
finding
बोल
has
रहे
been.
हैं, आप बोल रहे हैं issues have not been properly framed as per the first substantial question of law.
इसमें है जो
Due to non-consideration of issue.
पॉइंट ऑफ डिटरमिनेशन देखा जाता है। पॉइंट पारा 7 देखा अपीलेट कोर्ट ने तो सही किया।
अपीलेट कोर्ट ने रिफ्रेम किया।
पॉइंट ऑफ डिटरमिनेशन तो है
कहाँ
ये
तक है?
देखा जाए whether the appellant have got right title over the suit land, यही तो विचार है, यही तो डिसाइड किया। इंटरनल पेज 11 देखा जाए।
Then the issue goes. Issue the first appellate court नहीं किया। Issue अब मतलब एक रह गया issue।
फर्स्ट appellate court ने प्रॉपर इशू फ्रेम किया, प्रॉपर पॉइंट ऑफ डिटरमिनेशन।
पारा
Issue
नंबर
the first
पारा नंबर 7
आप first appellate court का है जो हम पढ़ देते
पारा
हैं।
नंबर 7 देखा जाए।
If my learned friend is satisfied, इसी पर हम first appellate court में क्या परसिटी है उसी पर हम दिखाते हैं।
Whether the lands are specified in plaint and the evidence of the appellant plaintiff, whether the plaintiff appellants have got right title and over the suit. मैं तो यही इसी पर नहीं इनको फाइंडिंग आया।
इस पर भी आपको ऑब्जेक्शन है?
क्या?
ये पॉइंट फॉर
ये
डिटरमिनेशन,
फाइंडिंग ही फॉर us।
ये वो अलग बात है फाइंडिंग इस पर बस, लेकिन पॉइंट फॉर डिटरमिनेशन तो सही फ्रेम किया है ना।
In absence of pleading, my contention is that
You had no pleading that you have your right title and interest.
the defendants have not pleaded that the property not specified.
अच्छा, identity of the property
They are not disputed.
is not in dispute.
हाँ, not in and the first appellate court has framed the points for determination. Even holding that the schedule A is specified. Even by holding that schedule A is specified.
कितना है?
इसको कल रख दिया था, कल हम पूरा कर देते हैं। मेरा डेट रखा गया है, फिक्स किया गया है।
कल
आज ही अभी किया गया है ऑर्डर 41/27 आइटम नंबर 25 हम फर्स्ट में मेंशन किए थे।
तो इसको सुनेंगे इसको कल,
हाँ कल।
लेकिन कल हम लोग ऑलरेडी 2 केस, देखिए कल परसों हम एक केस 2:15 बजे रखे हैं, उसके बाद इस केस को सुन सकते हैं। जब ऑलरेडी एक केस फिक्स्ड है तो हम कैसे करें?
मंडे को रखा जाए।
मंडे को, फ्राइडे।
मंडे को फाइनल डिस्पोजल।
सेकेंड अपील नंबर 328 ऑफ 2016, उसको थोड़ा सा लिखाए थे एडिशनल एविडेंस पर। द हियरिंग हैज रिमेन इनकंक्लूसिव, पोस्ट दिस केस फॉर फर्दर हियरिंग डे आफ्टर टुमारो एट 2:50 after the case which is already fixed है। तो ना नोट बनाइए,
हाँ बना।
आप लोग भी नोट बनाइए। चलिए ऑर्डर करते हैं।
Now under the heading hearing under order 41/11 CPC serial 36 SA 69 of 2023.
appellant.
This appeal is directed against the judgment dated 31/1/23, decree 8/2/23. In a case of reversal, the
Suit was decreed.
suit was decreed in favor of the plaintiff. Eviction suit was filed lordship. And case 13 is the first title eviction suit number 120 of 2011. Just I have explained
Eviction suit on what ground?
on ground lordship that he claimed, the plaintiff claimed the land portion of plot number 759, 760 under khata number 118, Mauja Karanji, yes, Parsuti Jamshedpur. Originally, the Syam Murmu was the owner of the suit land. Syam Murmu is the father of the plaintiff lordship, whose stood recorded in the name in the service settlement published in 1960. After death of Syam Murmu, two sons were there, one Jagat Murmu and one Srimat Murmu. There is a amicable partition between two brothers, and this plot of land along with house that fell in the share of the plaintiff.
Plaintiff is Jagat or Sripat.
Jagat, elder brother. Now the case of the plaintiff is lordship. It is Radom Murmu. He is uncle of the plaintiff, and he allowed him as a licensee.
The Sripat is the
Sripat. Syam Murmu was the father of the Jagat Murmu.
Yes.
Syam Murmu had two sons.
Okay.
First Jagat Murmu and second Srimat Murmu.
Okay.
Now in 1964 service settlement, the land was recorded in the name of the petitioner lordship, plaintiff. Thereafter, Radom Murmu, he is the uncle of the plaintiff.
Uncle मतलब कैसे uncle?
Chacha.
अच्छा. Okay.
Now he allowed him to live in the house as a licensee, and there was a permissive possession upon the land, upon the house. So he filed a eviction suit in the year 2011. Prior to that, he issued a notice. He asked him to vacate the house. He did not vacate the house. Then he issued a legal notice. He did not reply to the legal notice. Then the eviction suit was filed lordship. And lordship may see that in para 4 of the page 16 lordship of the trial for judgment.
Just a moment. What are the issues, ma'am?
Issues, yes, lordship. Para 4, page 16 of the trial for judgment. Internal page 4. 8 issues were pending.
Just a moment. Page 16.
Running page 16, internal page 4. Para 4 lordship.
Yes.
On the basis of rival pleadings on dated 17/4/13, altogether 8 issues were framed, which is as follows: whether the suit is maintainable in its present form for the relief claim, whether the plaintiff has got valid cause of action for bringing the suit, whether the suit is barred by limitation, waiver, estoppel, and acquiescence. Fourth, that this is important, whether there exists relationship of licensor and licensee between the plaintiff and defendant in respect of the suit premises. 5, whether the defendant was in permissive possession of the plaintiff, or whether the plaintiff is entitled for eviction of defendant from CUA premises.
4 and 5 are important.
4 and 5 are important. 4 and 5 lordship, and altogether lordship may see para 5. 4 documents were exhibited. Usi mein para 5. During evidence of the plaintiff has adduced 3 witnesses in support of his claim: PW1 Jagat Murmu, he is the plaintiff; PWT Narayan Chaudhary, and PW3 Gauranga Das. Now, Lordship, Exhibit 1 is the carbon copy of the legal notice dated 19/4/2011. Exhibit 2 is the postal receipt dated in 19/4/2011. And Exhibit 3 is the
What is
correction.
the document of your title?
Title of the document, Lordship, correction, Exhibit 3.
Correction slip थोड़े document of title बन जाएगा. What is the document of your title?
That is the full document which has been
This is not, no, none of them is title document.
Lordship, in fact, in 1964 survey settlement, the name of the plaintiff is appearing in 1964, and that is the root cause of fighting this eviction suit.
This rent receipt is not document of title.
Yes, Lordship, I do admit that revenue records neither creates any right nor extinguishes any right. It is used only for the fiscal purposes. But even then, Lordship, under the Homestead, Jharkhand Homestead Maintenance of Records Act, if there is a record to that effect, that the land is in my possession and from 1964.
Possession is something else. Revenue receipt, this is not a record of right. This is revenue receipt. Revenue receipt is not record of right.
Mutation, that is correction slip showing mutation.
Correction slip. That is, this is not record of right.
Lordship, may see the issue number 4 and 5.
Showing mutation, on what basis it was mutated, in whose name it was standing, what is your title deed?
In fact, Lordship, the land was initially in the name of the father of the plaintiff, Syam Murmu. And after death of Syam Murmu, the land fell in share of this plaintiff, Lordship.
How? Is there any previous partition?
But Srimat Murmu, the second brother, he has not objected to that.
There is a finding that there has been no partition, and both the parties belong to the same family. And if there is no partition, then you cannot have exclusive title over the property, and therefore he cannot be termed as a licensee.
पार्टीशन में जहाँ तक लॉर्डशिप में से कि इसमें इन लोगों का फैमिली की ये हुआ था, उसी वजह से इसको मिला था। ये DT.11 का जो है पैरा 7 हम पढ़ रहे हैं, ट्रायल कोर्ट जजमेंट का पैरा 7। DT.11 Jagat Murmu has stated in line of pleading a supported in his cross instance that he had brought the case against the defendant for eviction of such premises. Further, he stated that the defendant is his uncle. Disputed land is not.
कुछ नहीं है आपके केस में. A partition should find. Second appeal number 69 of 2023. For the learned counsel appearing, कुछ substantial questions.
Just for a moment, Lordship, the substantial question which I have framed, Lordship may see page 7, Roman 13, 23. Just for a moment, Lordship.
Page 7.
Page 7 of the
This is not substantial question, it is just grounds.
Ground में substantial question है।
बताइए कौन से substantial question में बताइए।
Page 9 में Roman 7. Whether defendant appellant is entitled to the rent of the suit property was paid by the plaintiff, that has been admitted by the defendant that the rent was paid by the plaintiff. Second, so Roman 7. Whether in the survey settlement of 64, the suit land is recorded in the name of plaintiff Father Syam Manji and documents Exhibit 3, correction slip, Exhibit 4, rent receipt, disclose the correction slip dated 8/6/2000 is in the name of plaintiff respondent, and rent receipt respectively copy of Form 27 in the name of Syam Manji. That is the point of possession, Lordship. So on this ground, I am in possession of the land, and Roman 8 में learned appellate court arrived at the wrong conclusion that correction slip, rent receipt are not going to prove any title of the plaintiff. He has reversed it only in this ground, and respondent has described that any partition took place between the parties by weeks and months. Both the parties are claiming suit property as their ancestral property, and these documents are prepared only for collection of. Two substantial questions of law, Lordship, and the defendant was in permissive position upon the suit as a licensee.
Heard the learned counsel appearing on behalf of the appellant. This appeal has been filed against the judgment dated 31/1/2023. Within bracket decree signed on 8/2/2023 passed by the Principal Judge East Singhbum, Jamshedpur in civil appeal number 17 of 2019, whereby the civil appeal has been allowed. The trial court judgment is dated 31/2019 within bracket decree dated 8/2/2019 passed by learned civil judge within Union Division -1 at Jamshedpur entitled eviction suit number 120 of 2011. The suit was decreed and the learned first appellate court has reversed the finding. Consequently, the plaintiff is the appellant before this court. The learned counsel for the appellant has submitted that the suit property belongs to the plaintiff and the specific case of the plaintiff was that originally Shyam Murmu, Shyam Murmu was the owner of the property of the suit land which stood recorded in his name in last survey settlement published in the year 1964. And after his death, it devolved upon the plaintiff and one Srimad Murmu. And during the lifetime, the suit property was handed over to the plaintiff. इसको खोलिए सर. फिर हटा दीजिए. ध्यान से. During the lifetime of their father, the suit property was handed over to the plaintiff. It was the further case that after amicable partition between the plaintiff and his brother, the suit fell in the exclusive share of the plaintiff. And the plaintiff constructed the house over the suit property. The specific case of the plaintiff was that the plaintiff had allowed the defendant to remain in the suit property on the basis of oral agreement, and therefore the defendant has been in permissive possession as licensee under the plaintiff. The suit property was required by the plaintiff for repair, but the defendant refused to evict, and consequently, after issuance of legal notice, when the defendant did not evict, the suit was filed seeking eviction. The learned counsel submits that the plaintiff had produced the correction slip showing mutation, though marked with objection, in his favor, and the rent receipt was also produced as Exhibit 3 and 4, rent receipt with objection, as Exhibit 3 and 4 he submits that these documents were enough to show that the suit property belongs to the plaintiff. The learned counsel submits that these documents have not been properly considered and has referred to proposed substantial question of law number 6, 7 and 8 which are quoted as under. After hearing the learned counsel for the appellant, the case of the plaintiff has been narrated by the learned counsel for the appellant. However, the records reveal that the defendant appeared before the court and claimed that the plaintiff was not the owner of the suit property. During the lifetime, the defendant's father had purchased the said property and constructed the house from his own income. And it was stated that late Lakhai Maji was the original owner of the suit property, who had two sons, Bhadva Murmu, defendant, and Shyam Murmu, the plaintiff's father, and one daughter who was unmarried. The defendant claimed that the father, namely Lakhai Manji, was an employee of Tata Iron and Steel Company Limited, and he had given service to his first son, that is Shyam Murmu, plaintiff's father, and the entire property was given to his second son, the defendant. And therefore the defendant claimed that he was living on the suit property on his own right, and there was no relationship of licensor and licensee between the plaintiff and the defendant. The plaintiff adduced both oral and documentary evidences. Exhibit 1 was the legal notice, Exhibit 2 postal receipt, Exhibit 3 is a correction slip showing mutation marked with objection, and Exhibit 4 is the rent receipt marked with objection. The defendant adduced himself as witness, and no documentary evidence as such was adduced by the defendant. The learned trial court considered the issue number 4, 5 and 6 as framed together by paragraph 10 onwards. The learned court recorded that it was not in dispute between the parties that the defendant is the own uncle of the plaintiff. But on behalf of the defendant, no documentary evidence was produced. The court also recorded that for the purposes of creation of license, no written instrument is necessary, And under section 54 of the Easement Act, the grant of license may be express or implied from the conduct of the grantor. And referred to the exhibit 1, 2, 3 and 4, and also the evidence of plaintiff's witnesses to prove that there was a relationship, who according to the trial court proved that there was a relationship between the plaintiff and defendant which existed as a licensor and a licensee, and accordingly decided the issue in favor of the plaintiff and consequently defeat the suit. The learned first appellate court, before the learned first appellate court, it was a case of the defendant that late Lakhai Manji is the original owner of the property, and it was also asserted that there has been no amicable partition between the defendant and the father of the plaintiff. And it was incorrect to say that the defendant is the licensee of the plaintiff with respect to the suit property. Rather, defendant is the absolute owner of the suit property, which was given by his father to him. The first appellate court the learned first appellate court considered the arguments of the plaintiff in paragraph 7 and wherein the counsel had submitted that 4 suits against different persons, that is titled eviction suit number 120 of 2011, the present suit. Number 2, eviction suit number 21 of 2011 against Nazir Suren. Number 3, eviction suit number 22 of 2011 against Dr. Balram Murmu, and eviction suit number 23 of 2011 against Kandu Tubu, and was filed, and all the 4 suits were standing on the same piece of land. And as the original documents were filed in eviction suit number 21 of 2011, he could not file the documents in the present suit. And the court also recorded that the court also recorded the submission that the plaintiff himself stated in his evidence that he is 2 brothers and 3 sisters, but he did not make party to them in the suit. The learned first appellate court framed the following points for determination. The court recorded that it was admitted case of the plaintiff that after amicable partition between the plaintiff and his brother, the suit property fell in his share. And he had given the same to the defendant under permissive possession. On the other hand, it was the case of the defendant that the property was standing in the name of their father, namely Lakhi Manji, who had purchased the property and had constructed the house, and that there was no amicable partition between the defendant and the plaintiff, and that defendant was not a licensee under the plaintiff. The learned court recorded that as per the settled position, the plaintiff has to prove his case, and the correction slip, the rent receipt, does not prove that there was partition between the parties by being meets and bound. And both the parties claim that the property was ancestral property. The court ultimately recorded that there is no permissive possession / licensor-licensee relationship between the parties, and there is no question of any permissive possession. The plaintiff admittedly did not produce any title documents and was claiming the property only on the basis of correction slip. The plaintiff and the defendant, they have common ancestor. The title of the plaintiff, the exclusive title of the plaintiff was denied by the defendant. In such circumstances, this court is of the view that the learned First Appellate Court was right in reversing the judgment of the learned trial court and does not find any perversity in the matter of appreciation of evidence, and no perversity in the matter of appreciation of evidence has been pointed out. The learned First Appellate Court has rightly held that the correction slip, etc., do not constitute document of title. Accordingly, this appeal is hereby dismissed.
So this is one case was mentioned, serial number 20. Can you follow? Serial number 25, SA 103 of 2024.
Yes, what is it?
Delay has been last year delay has been continued. That is that's subject to deposit.
Yes, what is it?
And now this is
You're the plaintiff?
no defendants.
Suit was decreed.
Suit dismissed, reversed in appeal. And the next trial, the basis of the claim of the plaintiff is the Sada Hukmnam. Of the predecessor interest, claim of the predecessor interest of the plaintiff was Sada Hukmnam. For the revision of the title by the manager, ward and company state. And thereafter, further claim of the plaintiff that she has purchased the land. And the learned trial court has held, while deciding this, that these documents by which the revision of title had not been brought on record, had not been examined. The learned trial court had, on that point, learned trial court had.
Hukunnama was exhibited.
No. No, neither.
Any rate receipt.
Neither Hukunnama nor Zamindari rate receipt.
But still the trial court decreed the suit.
No, trial court dismissed the suit.
Dismissed.
Appellate court reversed it.
Reversed it by saying what?
Uh,
Any additional evidence?
No.
Okay. What was the ground for reversal?
The ground for reversal by the appellate court that since the document has been marked exhibit in another case and the certified copy of the same is in the record, that's why he has reversed.
No. You said that this this particular document, the Hukumnama, was never exhibited.
No, very good.
The certified copy was also never exhibited.
No, not exhibited. But the first appellate court has held that since it is before him on record.
Okay. In another case.
In another case. Copy obtained from another case.
How?
Without either additional evidence or invoking it.
How the evidence in another case can be taken into consideration in this case? You are for the respondent? Yes, how the evidence of another case can be taken into consideration in this record?
Even order 41/120.
This is a case where the same settlement was in question.
Maybe.
Yes, one settlement in the name of Vindhyavasini Devi in the year 1942 was in question, and that matter has ultimately been decided by Your Lordship on others with regard to the same property, same settlement, another.
In second appeal, we will not look into that. We will just see whether the material which is not brought on record by way of evidence can be taken into consideration to decide a case.
But we had brought the judgment decree of the trial court, appellate court, and
it is
the
of no
certified,
relevance.
because we could not have the Hukumnama directly, we could not get it.
There are ways and means. If it is exhibited in another record, you can call for the record, get it exhibited in this case also. Parties are the same.
No.
Parties
are
original
also,
party is the same who had transferred.
That's right. That's right. But the parties are not the same.
Yes, party. The one of the
ये तो
property.
ऐसे ये तो बोलिएगा तो ऐसे ही सेट असाइड कर देते हैं इसमें क्या है आप दूसरा जगह का
Case the same has been lost.
नहीं, but लेकिन वो एक ही settlement was in
उससे क्या मतलब है?
ये था
उससे क्या मतलब है?
विंध्यवासिनी देवी के नाम से जो settlement हुआ 1942
इससे कोई मतलब नहीं है.
Now विंध्यवासिनी देवी is transferring a portion to me.
You will show me some law that if a document is exhibited in another suit without being exhibited in this suit can be taken into consideration and judged.
Certified copy was already.
It's irrelevant. It's irrelevant. Evidence of another case cannot be looked into like this. That is not permissible under law.
So the substantial question without meeting the reasoning.
आप कौन हैं? Sole plaintiff है ना? तो बस इतना ही बनाते हैं और इसको सुनते हैं.
A और D जो देख लिया.
बताइए कौन सा?
हमने A और D देख लिया. हमने जो substantial question A और B.
A और B.
A और D.
Reasons. ये क्या without meeting the reasons? ये थोड़ी है.
A, substantial question number A, that the learned report of in reversing judgment of declared learned without meeting the reasons of the learned trial court as ordinary. And D, in the absence of any proof of the plaintiff's case has pleaded, resting his claim on the basis of arrested Hukumnama, followed by the Zamindari suit in 27. One, with the Vasini Devi, both which were not marked as guilty, the suit could have been declared by the first appellate court.
D से तो हो जाएगा. D हो जाएगा.
है तो और मैनेजर has no power to sit up, लेकिन उसमें आ जाएगा.
That also may be claimed, but that has already been decided by the honorable court.
Manager having no power. Manager is only for managing.
That would be
जजमेंट इसका जजमेंट
This is the order which was
How the-
same, but it
One
would
other-
ultimately fall for.
वन अदर केस में
Same Vindhyavasini Devi transferred the property to plaintiff of that suit and to me also. And same settlement is in question in this proceeding also. We are only purchasers of different purchasers, that is the only difference.
ये फाइनल हो गया?
नहीं, ये सुप्रीम कोर्ट में चैलेंज किया है, डायरी नंबर है, but it was defective. ये तो लास्ट ईयर का
और उसमें इसमें बाय लर्नर ट्रेंडिंग रेफरिंग इसमें एडवर्स पोजीशन का भी था और
कोई बात नहीं, इसमें एडवर्स पोजीशन भी डिक्लेयर कर दिया क्या?
नहीं मुझे नहीं किया
You see the only
हाँ,
the
ये
only
नहीं
point
किया।
is D से होने से हो जाएगा।
हाँ डी कर दिया माय कंटेंशन वन विदाउट मीटिंग द रीजनिंग ट्रायल कोर्ट का उन्होंने कर जो डॉक्यूमेंट नहीं है एडिशनल एविडेंस इन्वोक हुआ है ऑर्डर 7 रूल 14 से द प्लेंटिफ relies on the document he must prove it at the time of filing of the plaint and that was not there और एडिशनल एविडेंस भी नहीं था और कोर्ट अपलेट कोर्ट ने अलाउ कर दिया
देखिए, the learned counsel for the appellant has submitted that the suit was dismissed on account of inter alia on account of non production of hukumnama followed by zamindari land receipts.
Yes.
However, the first appellate court has allowed the appeal by referring to certified copy of certain documents which were exhibited in another suit. And these documents were not brought on record by filing any additional evidence, and accordingly they were not marked exhibits. He submits that the evidence laid in one suit cannot be automatically utilized in another suit. This becomes all the more serious when the parties are not the same. He has referred to substantial question of law number D. The learned counsel has also submitted that if the unregistered hukumnama and zamindari rent receipt do not fall, are taken out of the consideration of the learned first appellate court, then the judgment of the learned first appellate court, which are based on these documents, cannot be sustained in the eyes of law. And the learned first appellate court has passed a very well-reasoned order dismissing the suit. यही है? Trial court. Considering the submissions, this appeal is admitted for final hearing on the following substantial question of law. एक तो डी होगा, दूसरा बी, एक और ए का कोई मतलब नहीं है।
तो आज कवर हो जाएगा, उससे कवर हो जाएगा।
इसी ग्राउंड पे ना अलाउ किया है आपका डी, और उसके बाद एक और whether the judgment passed by the learned first appellate court can still sustain in absence of the documents which has been used and not exhibited in the present proceedings.
Under order 41 rule 27 or any
हाँ, not exhibited or not brought on record under order 41 rule 11 of CPC. उसके बिना भी सस्टेन कर सकते हैं तो बता दीजिए। ठीक।
Can I play for Monday?
Monday रिकॉर्ड आ गया क्या?
अच्छा। नहीं, ठीक है। जैसा आजकल तो जितना जल्दी हो, हमसे नहीं हो रहा।
Let the records be called for from the concerned court upon deposit of special messenger. The special messenger must be deposited within 1 week from today.
इसमें आइए था
The respondents have already appeared, therefore no notice need be issued. आइए क्या
is for staying the further proceeding of execution.
क्या किए क्या हो रहा है
ये जो डिलीवरी ऑफ पोजीशन के लिए
आइए नंबर 8083 of 2025 the counsel for the appellant prays for stay of the execution proceeding case number 18 of 2024 pending in the court of
any report of learned subjects to
learned subject Roman 2 Chatra. He has submitted that steps are being taken for delivery of possession. Post this case on ऐसे open stay order यहाँ नहीं होता.
हाँ ठीक है
कब करिएगा ये बताइए.
हम तो जब मुझे रहेगा
आप चूज करिए आप अपना डेट
रिकॉर्ड रहेगा थोड़ा
रिकॉर्ड तो 1 मिनट में आप जमा करेंगे
हम तो जमा कर देंगे जमा कर देंगे
1 वीक में जमा कर दीजिए डेट आप बता दीजिए बताइए कौन सा डेट मंडे तक तो रिकॉर्ड नहीं आएगा ना
मार्च में ही
We cannot.
यू कैन हैव इट बोथ डेज
हम जमा कर दे रहे हैं हम 1 वीक में जमा कर रहे हैं
तो आपका
मार्च में
20 आपका तो आ जाएगा 18th को आप जमा करेंगे मार्च में होगा ना
हां तो मार्च में होगा
उसके पहले कैसे होगा
ठीक है लेकिन ये स्टे करके अनडे
तो
स्टे करके ऐसे नहीं रहेगा स्टे टिल दैट डेट ही
टिल
रहेगा
दैट डेट हम नहीं मांगे
Pose this case for final disposal on 18th March. The further proceedings in the execution case shall stand stayed till 18th of March 2026. The parties have agreed to finally argue the matter if the records are received prior to that date. Communicate.
Now, CR 37 SA 171 of 2025.
In the titles put filed by defendant lordship, the respondents, they are the defendants. That has been allowed. Subsequently, we have referred appeal after the delay of 2,495 days. On the basis of one judgment passed by this honorable court in LPA, my second appeal has been, first appeal has been dismissed without condoning the limitation of
No,
application.
it's a huge delay. There is no explanation. What kind of allegations you are making? You are making an allegation कि ठप्पा लगवा लिए, written statement गलत फाइल कर दिए, पूरा documents गलत execute हो गया. What is this?
यही हुआ
नहीं ये हुआ है तो क्या हुआ?
नहीं हुआ तो ये
Written statement फाइल किए थे ना? गवाही दिए?
उस एलपीए का जजमेंट
क्या हो गया?
जो एलपीए कंसीडर करके मेरा केस डिसमिस किया
कोई बात नहीं भाई लिमिटेशन पे केस डिसमिस किए.
हां
Condonation of delay का grounds बताइए.
डिले का ग्राउंड यही था कि वी आर नॉट हैविंग नॉलेज द अपीलेंट इज नॉट
अचानक कैसे नॉलेज आ गया? कहाँ से?
एग्जीक्यूशन होने लगा ना तब नॉलेज आ गया और वो रिमांड हुआ था जिस एलपीए का कंसीडर करते हुए मेरा केस डिसमिस हो गया एज नॉट मेंटेनेबल. मेरा फर्स्ट अपील डिसमिस हुआ. डिसमिस एंड कंसीक्वेंसेस इज द अपील इज टाइम बार्ड द सेम इज आल्सो डिसमिस एज नॉट मेंटेनेबल. बस नॉट मेंटेनेबल नहीं करना.
कोई बात नहीं इससे कोई फर्क नहीं.
और जो ये कंसीडर किया ऑर्डर वो रिमांड हो गया है ऑनरेबल सुप्रीम कोर्ट से. एलपीए का ऑर्डर
You just see the finding, read the finding
यस
of the court. यहाँ से पढ़िए.
पेज 60 से
पेज 59 से पढ़िए.
59 से
59 से. एक सेकेंड.
58
एक सेकेंड नहीं नहीं.
57 से एक पैरेग्राफ
नहीं नहीं ये 58 से पढ़िए. After receiving notice. After receiving
after
notice.
receiving notice of the title suit number so and so son in law of the appellant Jogendra Mahato applicant defendant to civil court only on one occasion, where her thumb impression was taken on few papers, and thereafter she was told by her son-in-law that son-in-law का भी death हो गया था.
कोई बात नहीं.
हाँ. Told by her son-in-law that he is gone disposed of, and since the applicant defendant was totally unaware about the legal proceeding and was totally dependent upon her son-in-law Yogendra Mato, and thereafter she believed on the version of her son-in-law that the titles got disposed of. It is further submitted that son-in-law of applicant namely Yogendra Mato was murdered by some criminal on 2018, and in this regard PS registered, and during the lifetime of Yogendra Mato, applicant never received any notice
सूट का
regarding.
एक सेकंड, सूट का डिस्पोजल का डेट क्या है? जजमेंट ऑफ ट्रायल.
हाँ, वो लगाया गया 53 पेज 53 9/6/2017
9/6/2016 2007.
हाँ, ये सिंपली ये है कि
आगे पढ़िए.
पहले ये भी थोड़ा सा बता देते हैं.
पढ़ के आए केस.
हाँ.
आगे पढ़िए. स्पेसिफिक परफॉर्मेंस का केस है ना?
हाँ, स्पेसिफिक परफॉर्मेंस है, लेकिन हम नेसेसिटी में जो एग्रीमेंट एग्जीक्यूट किए इसके मुताबिक प्लेटिव के मुताबिक वो 20,000 रुपए हम लिए और 1,41,000 रुपया उनके पास छोड़ दिए. टोटल 161,000 का केस था.
आप पढ़िए. It is further submitted that.
It is further submitted that few months ago applicant received notice of execution case number so and so, and thereafter she rushed to civil court and met with an advocate of civil court Ranchi, who assured applicant that he will look after the case and took proper steps, but he took no steps in said execution case, and lastly said that applicant will have to execute said deed in favor of Dinesh Kumar. Then applicant engaged agent lawyer for taking steps in execution, and thus she was advised to file appeal against the judgment and decree. Thereafter applicant applied for certified copy of judgment and decree, which was delivered on 22/3/24, and thereafter handed over to her lawyer for filing appeal. It is humbly submitted that applicant is totally unaware of legal proceeding, and she never received any notice from respondent, plaintiff, nor from the learned counsel except receiving of notice of title suit number so and execution, and in fact never she participated in trial of the suit. It is further submitted that the applicant has no knowledge about impugned judgment and decree, and she came to know about the same recently when she received notice of execution case number 8/2020. It is further submitted that delay of almost 2475 days, ये 2475 days नहीं है, 2495 days है, जो लास्ट 50 रहेगा अलग डेट.
कितना डेज है?
2495 है, ये अभी नेक्स्ट पेज में पेज 61 में आएगा. पेज 61 में in filing this appeal occurred due to want of knowledge and ignorance, and the same is not in any way intentional on the part of applicant. It is submit also contended that the applicant has gone good defense against the claim of plaintiff respondent, but in spite of that, no evidence is used on her behalf in trial of the title suit number so and so, and that is due to her ignorance, as because she was kept in dark by her son-in-law Yogendra Mato, and in fact she was kept away from the trial of the suit. It is also submitted that suit property is the only property of applicant, as well as source of livelihood, and there is very good defense against the claim of the plaintiff respondent, and if she is not given a chance to defend her case, she will suffer irreparable loss, hence for the end of justice. Having gone through the submission as made above for delay combination as well as considering the materials available on record, it is evident that admittedly the suit was filed by the respondent. यहाँ plaintiff लिखा हुआ है कि defendant for respondent ठीक लिखा हुआ है.
respondent plaintiff for specific performance of contract in the year 2011 wherein the appellant has appeared and contested the suit by filing a written statement denying any agreement for sale for the suit property, and ultimately after the trial of the suit an effective judgment and decree was passed against the appellant in her presence by judgment and decree dated so and so respectively, but she could not refer the appeal within the statutory period of 30 days from the date of passing of such said decree, and in view of the discussed fact, I would like to rely upon the judgment passed by the Honorable High Court of Jharkhand, Ranchi in SBA number so and so, wherein it is held in para 9 that it is settled law. वो judgment है क्या? LPA का.
It's everything.
It is settled law that when a litigant does not act with bona fide motive and at the same time due to inaction and lapses on its part, the period of limitation for filing the appeal expires. Such lack of bona fide and gross inaction and negligence are the vital factors which should be taken into consideration while considering the question of culmination of delay. In this regard, of considering the ground taken by the appellant defendant in her delay culmination petition, I find that the same is not sufficient and reason to condone the delay and appeal is statutorily barred by limitation of 2495 days, and thus the delay culmination period is devoid of merit is hereby dismissed, and consequently since the appeal is time barred, the same is also dismissed as not maintainable, and the appeal is dismissed.
Or the learned counsel appealing. Second appeal number 171 of 2025. Heard the learned counsel appealing on behalf of the appellant. This appeal has been filed against the judgment dated 2/7/2025, whereby the learned first appellate court has dismissed the appeal, dismissed the first appeal, and on the point of limitation, and has held that the appeal was not maintainable. The trial court had decreed the suit by judgment dated 9/6/2017 within brackets, decree signed on 17/6/2017 in title suit number 387 of 2011, relating to specific performance of contract for sale of landed property. The learned counsel for the appellant has submitted that the learned first appellate court has referred to the judgment passed by this court in LPA number 54 of 24 with IA number 1123 of 2024, whereby the learned LPA court had refused to condone the delay in filing the LPA, but the said judgment of LPA court has been set aside by the Honorable Supreme Court in special leave petition within bracket civil bracket closed diary number 57008 of 2024. The learned counsel has submitted that the very basis on the for which the learned first appellate court has refused to condone the delay does not exist anymore. After hearing the learned counsel for the appellant, it is not in dispute that the suit was decreed on 9/6/2017, and there was delay of 2495 days in filing the first appeal. And it is however the grounds for however the entire sequence as narrated by the appellant has been recorded in the impugned order refusing to condone delay.
Supreme Court का
The
जो order था,
just a moment. The appellant had stated that the appeal could not be preferred within the statutory period of limitation, as the appellant is illiterate widow, village lady, who is blessed with only 3 daughters and had no son. So his younger son-in-law, namely Jogendra Mehto, now deceased. So she kept her younger son-in-law, namely Jogendra Mehto, now deceased, with her, but he was completely drunkard and mischievous person and fraudulently obtained thumb impression of the appellant on various blank papers and non-judicial stamp papers, and in order to grab her landed property, he connived with the plaintiff and converted blank papers into sale agreement for sale of plaintiff's ancestral property.
which is not registered.
And he himself became a witness of the sale agreement dated 9/6/2010. And it was this sale agreement which was filed in title suit seeking specific performance of contract. It has also been recorded that the said son-in-law has expired in the year 2018. The appellant further has stated before the first appellate court that after receiving notice in title suit number 387 of 2011, son-in-law took the appellant to civil court only on one occasion, where again her thumb impression was taken on few papers, and thereafter she was told that by her son-in-law that the case got disposed of, and since then the appellant was totally unaware about the legal proceedings and was totally dependent upon her son-in-law, and she believed the version of her son-in-law that the title suit got disposed. The son-in-law was murdered on 27/12/2018. It was also asserted that the appellant thereafter never received any notice regarding the suit except in the execution case, which was numbered as execution case number 8 of 2020. Upon receipt of notice, she rushed to the civil court and met with an advocate who assured that he will look after the case and take proper steps, but he took no steps in the execution case. And lastly, the advocate told the appellant that the sale deed will have to be executed. Thereafter, the appellant engaged another lawyer for taking steps in the execution case, who advised her that the first appeal is to be filed against the judgment and decree passed in title suit number 387 of 2011. And thereafter, the appellant applied for certified copy on 14/3/24, and which was delivered on 22/3/24, and ultimately the appeal was filed. The appellant also asserted that she never participated in the and the ground for condonation of delay was want of knowledge and ignorance. The appellate court recorded the finding as under. The findings clearly reveal that in the suit the written statement was also filed, denying the agreement to sale, and ultimately a judgment and decree was passed. The court referred to the principles of law enunciated, and the principles of law with regard to condonation of delay as mentioned in LPA number 54 of 24, wherein the LPA court had observed that when a litigant does not act with bona fide motive and at the same time due to inaction and laches on its part, the period of limitation for filing the appeal expires. Such lack of bona fide and gross inaction and negligence are the vital factors which should be taken into consideration by considering the question of condonation of delay. No doubt the order of the LPA has been set aside by the order of the LPA has been, and the order of the LPA refusing to condone delay has been set aside by the Honorable Supreme Court. But the Honorable Supreme Court has perused the application for condonation of delay and was satisfied with the reasons assigned for condonation of delay. So far as the principles of law with regard to condonation of delay is concerned, there can be no doubt that if a litigant is not acting bona fide and there is negligence or inaction on the part without any explanation, the delay cannot be condoned. There is enormous delay in the present case. In the appeal filed by the appellant before the First Appellate Court, she had, and admittedly the written statement was filed. Her son-in-law had told her about the disposal of the suit. In spite of receiving notice, in spite of that, she did not take any steps. Further, when she received notice in the execution proceedings, she engaged a lawyer, but no details of the lawyer has been mentioned. And just a moment, she engaged a lawyer. She engaged a lawyer, and thereafter she engaged another lawyer, and then the appeal was filed. This court is of the view that further the appellant has made numerous allegations regarding fraudulent method of obtaining thumb impression, etc. in the petition seeking condonation of delay. This court is of the view that the learned First Appellate Court had rightly considered the conduct of the appellant by refusing to condone the delay. This court finds no reason to frame any substantial question of law in this appeal. This appeal is accordingly dismissed.
In view of Supreme Court judgment, Lordship, it is required to be remanded.